Good morning. Before the conference begins, I would like to remind you all to switch off your phones or set them on silent mode. Thank you. Good morning, honorable speakers, ladies and gentlemen. As a member of the organizing committee, it's my great pleasure and privilege to welcome all of you to the first edition of the France-UAE International Arbitration Conference, hosted by Paris Dauphine and jointly organized by Al-Tamimi & Company law firm in Dubai and the Club Éthique Finance Elite. In recent years, many Gulf countries have taken steps to make arbitration more attractive. Among other developments, a number of jurisdictions have enacted arbitration laws based on the UNCITRAL standards, which limit the role of the courts and recognize party autonomy and greater authority for arbitral tribunals. The UAE and the Kingdom of Bahrain have gone further by establishing separate common law jurisdictions such as the Dubai International Financial Center, the Abu Dhabi Global Market, and the Bahrain Center for Dispute Resolutions, in cooperation with the American arbitration associations, which they are actively promoting as arbitral centers. On the other hand, Paris, being the world's leading arbitration capital, with legal councils renowned for their excellence in the field, it was only but natural for us to organize this conference intended to strengthen the bonds between the legal communities of these two countries and to address our respective latest positions on arbitration. In this respect, we have today a very impressive lineup of panelists who will provide through session 1 an overview of the latest developments and trends in the arbitration sphere through a comparative approach, France as a major worldwide arbitration hub, and the UAE as a growing arbitration hub. Through session 2, the speakers will provide you with an overview, again through a comparative approach, on the issues arising from the recognition and enforcement of foreign arbitration awards, respectively in France and in the UAE. It's my great honor to express our gratitude to all the distinguished speakers of this first edition of the conference. I sincerely hope that you will enjoy today's debates. To begin, I would like to call upon Monsieur Alexis Moore, President of the ICC International Court of Arbitration, to deliver his keynote address. Alexis Moore has served as parties counsel, President of the Tribunal, co-arbitrator, sole arbitrator or expert in more than 2,050 international arbitrations, both ad hoc and before most international arbitration institutions. He established his own arbitration practice in May 2015 after having founded Castaldi, Moore & Partners in 1996. Now a 35-lawyer firm specializing in arbitration and dispute resolution. Since July 2015, Alexis Moore has been the president of the ICC International Court of Arbitration. He was vice president of the ICC Institute of World Business Law from 2011 to 2015. Formerly, he had served as co-chair in the IBA Arbitration Committee from 2012 to 2013, LCEA court member from 2012 to 2015, and council member of the Milan International Chamber of Arbitration from 2006 to 2014. He is a member of a large number of scientific and professional institutions dedicated to arbitration and private international law. He is the founder and former president of Paris Place Arbitrage. Monsieur Moore, it's a great honor to have you here today among us. Please join me in welcoming Monsieur Moore.
Nadia, thank you very much for inviting me today. This is a great event. I have to commend you for organizing and taking the initiative to launch this first France-UAE International Arbitration Conference. And with Al-Tamimi & Co. and McDermott, Will and Emery, joining forces with LexisNexis. You have excellent sponsors, and I'm sure that the success of this conference today will pave the way for many future editions of these events. And these bilateral events are indeed extremely useful, for they allow to exchange views, to cross experiences between practitioners of different cultures and legal backgrounds. I myself have initiated a similar kind of event. It is the Franco-Spanish arbitration encounters, las miradas cruzadas franco-españoles, which take place every year, once in Paris, once in Madrid, and which I believe have contributed to developing the arbitration culture in both countries. And while we inaugurate this first edition of this conference, we of course should not forget that France and the Emirates have a long history in arbitration. One of the most important cases in the French case law on a topic that you will surely discuss today, the enforcement of an annulled award, originated, as you know, in Dubai. It was the Bechtel case, and in the Bechtel case, the award was annulled in Dubai based on the fact that the arbitral tribunal had not taken the oath of witnesses according to local procedural requirements. At the time, the Emirates were not yet part of the New York Convention, but there was a bilateral judicial convention between the two countries. That bilateral treaty applied to arbitration as well as to judicial proceedings, and it obliged both parties to recognize and enforce court decisions rendered in the other country. And arguably, that treaty would have obliged the French courts to recognize the decision made by the Emirati courts and the Supreme Court, the Court of Cassation in the Emirates, having annulled the award. To the contrary, the Paris Court of Appeal in this Bechtel case decided that the Emirati annulment decision only produced territorial effects and by its own nature was not susceptible of being recognized internationally. And this has been one important step in the evolution that has led to what we know today as the Poutrabali case law. We in France do consider, rightly or wrongly, this is a topic for endless debate, that a decision made at the seat of the arbitration annulling the award is a local decision and is not susceptible of being enforced, and this even in spite of a treaty clearly providing to the contrary, as it was the case in the Bechtel dispute. And therefore, I suppose that this will be one of the topics that we will discuss today, but it is interesting that the Emirates was in a way at the origin of this debate that is now, of course, a global debate. We are meeting today in the times of fundamental changes for arbitration. Arbitration, first of all, as you know, is under the public watch as it has never been before. We have witnessed in the past years, in occasion of the negotiations of the TTIP, the Canada-EU treaty, we have seen the incredible backlash against investor-state arbitration. And much of the criticism that has unfolded against arbitration in this debate is unfair, but not all of it. It is in part grounded on objective and I would say founded criticism against some of the features that have developed in investor-state arbitration. And in large part, this criticism go beyond the boundaries of investor-state arbitration, and it also touches upon international arbitration in general. The questions of transparency, of ethics, of diversity are now before us, and they need to be addressed extremely seriously. We, the arbitration community, are a community in which there is, I would say, and I speak for myself first, a lot of complacency. I think time for complacency in arbitration is over. If we do not act decisively to protect the integrity of the global system of international justice that arbitration is, we will be sooner or later swept away. States will step in with the aim of regulating arbitration in a way that is undesirable. And we have, we have an excellent example of that in the Emirates. We have an example of that in the Emirates where a statute has been introduced criminalizing the arbitrator's lack of independence and impartiality, as you know, and that, from my perspective, is the worst possible way to address the question of ethics in arbitration. That kind of statute will favor judicial interferences, and not good ones, in the arbitration, and it will ultimately deter parties and arbitrators to sit in Dubai. We have seen some examples of that already. Tribunals agreeing with the parties to move the seat of the arbitration out of Dubai to avoid, of course, the risk of the arbitrators being criminally prosecuted for allegations of lack of independence. And I believe that the proper answer to the real and legitimate questions that are on our table today are not answers of this kind. The proper answer should emanate from the arbitration community. It should be soft law, transnational regulation emanated from the arbitration communities. For arbitrators, it is the strong role of arbitral institutions in ensuring that conflict disclosures are made in a forthcoming and transparent manner, in removing arbitrators that do not comply with their ethical duties. And we at the ICC are taking a very robust stance on this. As some of you may know, we have last year adopted rules of our own on conflict disclosures, which you can find in the ICC note to parties and arbitral tribunals. Those rules are different from the IBA guidelines on conflict, and they are aimed at encouraging arbitrators to disclose in the most transparent and forthcoming manner, based on the fundamental principle without which there is no system of arbitration, that the parties are entitled, they have a right to be aware of any circumstance that in their eyes can be such as to cast a doubt as to the arbitrator's independence or impartiality, because if that information is not on the table, then the parties are deprived from their right to object to the constitution of the tribunal or to mount a challenge with, of course, awful consequences in terms of the challenge being made against the award years after, with the consequences that of course we all know. For counsel, I submit that the only workable and useful answer to the again legitimate question of counsel conduct in arbitration is the one that has been adopted by the IBA in adopting the IBA guidelines on party representation in international arbitration. Again, transnational rules that reflect the diversity of legal cultures in arbitration, rules that do not lead to favoring judicial intervention in the arbitration or parallel proceedings, and rules that empower the arbitral tribunal to deal with these matters insofar as they create a risk for the integrity of the arbitral proceedings. The LCIA has, as the first institution to do so, taken, and it is most welcome initiative, has adopted rules, as you know, on council conduct in the LCIA rules. Then the Australian arbitration institution, the ASICA, has decided to incorporate into its rules the IBA guidelines on party representation, again, a much welcome initiative. And the ICC has now, last month, decided to also adopt the IBA guidelines. There is, in the latest version of the note to parties and arbitral tribunals that is on our website, a new section on the conduct of participants in the arbitration, whereby the court sets the rule that it expects all participants in the arbitration, including, of course, counsel, the party representatives, to act honestly, professionally, with integrity. And in this new section, we encourage the parties and arbitral tribunals to draw inspiration from, or when appropriate, adopt the IBA guidelines on party representation. And I think that is a great step forward towards establishing what is much needed, and that is a level playing field as far as counsel's conduct in arbitration is concerned. The second evolution that is a fundamental change in the arbitration landscape is the new awareness that now exists since some years as to the time and cost of the arbitration. The time and cost of the arbitration has, in many instances, gone out of control, driven by bad practices, by lack of awareness on the part of counsel, in many instances by the lack of availability of arbitral tribunals, the inability of arbitrators to display sufficient authority. There is the so-called due process paranoia and the inability in many instances to act proactively in order to ensure that the arbitration is conducted in a way that is in accord with the amount in dispute and with the expectations of the parties. The business community is no longer prepared to accept that situation, and it is again incumbent upon arbitral institutions to take measures to react to this. And this is why we at the ICC have adopted, in the latest version of the ICC Rules of Arbitration, a set of expedited rules which I believe are a bold and novel answer to the legitimate concerns of the users as to the time and cost of the arbitration. Those rules which are applicable on an opt-out basis to all arbitrations in which the amount of dispute is lower than $2 million, and that means that whenever the amount of dispute is below that threshold, the expedited rules will apply irrespective of any contrary provisions unless the parties have decided to opt out. And it can also apply on an opt-in basis to all other arbitrations. And these rules effectively provide for a resolution of the dispute, for an award being made in 6 months effectively. It is not the 6 month time limit that applies to ordinary arbitration. It is a 6 month time limit that the court will expect to be complied with by arbitral tribunals, by a sole arbitrator appointed by the court, irrespective of any contrary provision of the arbitration agreement, and that arbitrator will have the power to decide the case on documents only if it believes appropriate, with no examination of witnesses or experts, if again it believes appropriate, with the power not to allow the discovery of documents, and with no terms of reference, with a reduced scale of fees, and therefore allowing the dispute to be effectively resolved in 6 months at a much lesser cost for the parties. So with this I will conclude. We need to address all these challenges. The ICC is doing so. Other institutions do as well. If we manage to meet the expectations of users, to meet the challenges of the new challenges of ethics, transparency, diversity, not only in investment arbitration but also in commercial arbitration, then arbitration will have a great future. And from that perspective, I think that this kind of event is has great value in fostering debate and helping progressing the collective reflection. Thank you very much.
Thank you very much, Monsieur Moore, for this uplifting address. It's now my pleasure to introduce you to Sarah Kolelat, which will be moderating this first session. Sarah is a senior associate with Dubai-based Al-Tamimi & Company, the largest law firm in the Middle East. In addition to her extensive transactional experience in corporate and banking law, Sarah has developed an extensive experience in cross-border complex litigation and arbitration, covering corporate and commercial law, banking and finance, real estate, and oil and gas. In addition to her practice of law, Sarah has held several academic and editorial appointments at renowned institutions. Prior to joining Al-Tamimi & Co., Sarah practiced law in Paris, London, and Beirut. Sarah holds a LLB from St. Joseph University, Masters in Law from University Paris 5, Advanced Master from ESSEC Business School, and an LLM from Harvard Law School. Sarah is admitted to practice in New York and Paris. Sarah, it's a great privilege to have you here today among us.
Hello. Thank you, Nadia. I'm actually very happy to be here with everyone on this first event of its kind. I am even more delighted to be part of this distinguished panel. To my right, we have Mr. Renaud Soriol, who's the director of the International Trade Law Division of the United Nations Office of Legal Affairs, which functions as a substantive secretariat for the United Nations Commission on International Trade Law. He took up his duties on October 1st in 2008. He joined the UNCITRAL Secretariat in 1989 and was particularly active in the development of UNCITRAL standards in the fields of international payments, electronic commerce, arbitration, and conciliation. A French national, Mr. Soriol holds degrees in private law from University of Paris II. He is also a graduate of the Institut d'études politiques of Paris and the École nationale de magistrature. I also have the pleasure of introducing Mohamed Shilbaya, who's a partner in Sherman and Sterling's arbitration practice based in Paris. Mohamed has represented companies, states, and state-owned entities in more than 30 commercial and investment treaty arbitrations with a particular focus on arbitrations in the oil and gas sector, and as well arbitrations involving many interests in the Middle East. He has also extensive experience advising energy companies regarding their contractual portfolio, as well as negotiating on their behalf with their major upstream and downstream counterparties. Mohamed has studied law at Cairo University and also obtained licence, maîtrise in private and Master 2 in private international law from Université Paris-Sorbonne. And as well as a Master 2 in litigation from the University of Paris 2, Panthéon-Assas. I also have the pleasure of welcoming Mercedes Torres Lagarde from the Dubai International Arbitration Center. Mercedes is a Mexican qualified lawyer with a postgraduate degree in international dispute settlement from the Graduate Institute of International and Development Studies in Geneva. She has been with DIAC for the past 4 years, and prior to joining DIAC, Mercedes has acted as counsel for cases before the Inter-American System for the Protection of Human Rights, as well as practice as an attorney with a renowned law firm in Mexico City. Last but not least, I have the pleasure of introducing Karim Nassif, who has more than 17 years of experience in arbitration, civil law, commercial and corporate law, as well as real estate and construction. He has acted as counsel, expert, and arbitrator in many complex commercial disputes under leading international and regional arbitration rules, including the rules of the ICC, LCIA, DIAC, GCC, UNCITRAL, ADCAC, and various arbitrations seated in the UK, France, USA, and across the Middle East. Karim has authored as well as co-authored several publications in English, French, and Arabic, and he has frequently been a speaker in international conferences and seminars on international arbitration and on UAE and Gulf laws in general. Karim has obtained an LLB and LLM with honors in business law and a diploma in law and IT from the University of Montpellier. Karim, additionally to his practice of law, is a lecturer in civil and commercial law. He is admitted to the Beirut Bar and is licensed as a legal consultant in Dubai. So welcome to all four of you. The purpose of this first panel is to provide our audience with the latest developments and trends with regards to the arbitration industry in both France and the UAE. We will entertain a discussion which will be followed later on by a Q&A session with the floor. To start off, I would like to probably ask Mr. Renaud Soriol to give us probably an overview of the instruments championed by UNCITRAL and, you know, the ones who are found to be more popular in the GCC as a whole, which, you know, as you know, Bahrain has made a general reference to the UNCITRAL law and their arbitration law, and obviously the UNCITRAL model law has been pretty influential across several jurisdictions. So we would be grateful for an overview of such instruments.
Thank you, Sarah. Good morning, ladies and gentlemen. So I was asked not to prepare a formal presentation, so I will maybe give you a few indications, as you suggested, on the state of affairs at UNCITRAL and the various instruments, and among those, the particular aspects that might be interesting from a Mid-Eastern perspective. Of course, we start with the New York Convention. And although UNCITRAL was created shortly after the New York Convention was adopted, UNCITRAL is in many ways an offspring of the diplomatic process that led to the adoption of the 1958 New York Convention. And at least as we understand it, our role since then has been to fill the many blanks opened or created by the New York Convention, which is, of course, the wonderful instrument we all know, but one that does not provide much guidance as to arbitration law and practice. So we have been, over the years, trying to create that substantive law of arbitration and also to provide the tools for a proper interpretation of those tools, always with a view to ensure the best possible functioning of arbitration as a dispute settlement mechanism. And we are still very much, 50 years after the begin of that work, trying to make sure that arbitration is not overlooked or not sidetracked, and the main reason being that we are firmly of the view that there is no serious alternative or workable alternative to a good arbitration system for the conduct of international affairs. So the New York Convention is not a particular problem in the Gulf. Although, of course, we have, because most states have actually ratified it, of course, when it comes to interpretation of the New York Convention, things could always be better, and I would start by mentioning one very recent instrument, which is not a normative instrument, it's not law, it's educational material prepared, and I'm happy to say this, in Paris, prepared with very active contribution by Professor Emmanuel Gaillard and also Professor George Berman from New York, to summarize case law on the New York Convention and provide the basis for a proper interpretation of the New York Convention. This is a tool which is, I have For the moment, it only exists in English, but we are in the process of getting this translated. So it's a fairly comprehensive document, which, in our view, will greatly assist with in particular, the training of judges in the field of arbitration. Now, being a judge myself, I have some sympathy for the, shall we say, reluctance or certainly the lack of familiarity expressed by some of my colleagues over the world when it comes to this seemingly unfair competition coming from the arbitration world, and the need for them to better understand how the system is intended to operate. So New York Convention is the beginning. Of course, I would also mention as a still fairly recent product of UNCITRAL, the recommendations we published for the interpretation of the New York Convention, in particular Articles 2 and Article 7. Article 2 being one that contains form requirements that well, need a bit of an update. Let's put it in that sense. And this is a case where the New York Convention probably needs to be interpreted to say exactly the opposite of what it says, that the arbitration agreement shall be acceptable in any form. Now, this is something which has been considered a bit counterintuitive by a number of people. This is also an area where the New York Convention shows its age. Ideally, in an ideal world, we should be able to revise the New York Convention to eliminate the uncertainties about the form of the arbitration agreement. That is, for a variety of reasons, politically at least unwise. And I think when this was comprehensively reviewed by UNCITRAL a few years ago, the idea was that we should limit ourselves to interpretation by way of declaration and General Assembly resolutions, which of course is not as legally satisfactory device as a revision of the text itself would have been, but probably the best that could be done at this stage. Now, leaving the New York Convention, of course, the next step is the 1985 UNCITRAL Model Law on Arbitration. This is a text which is probably the main, one of the main pieces where we are going to discuss here today. I would probably leave it for questions and answers. I will not give you a detailed presentation of the model law. It is a small code of procedure. It's a small code of arbitration. It is, I think, de facto recognized as the world reference. I wouldn't say that this is the model followed by all, or indeed necessary that it is desirable to follow it word for word, but it is definitely a universal reference which I would say cannot be ignored by any legislator revising arbitration law or creating new arbitration law. It is currently in force in a little over 100 jurisdictions, which does not mean over 100 states, because, of course, in many, in particular federal states, arbitration and arbitration procedure are state or province matters. But you should remember that we have the model law in force in I think around 75 states and over 100 jurisdictions. The model law was revised in 2006, and we have a number of, I would say, generations or waves of enactment of the model law, and this may be an issue which we might further discuss. For example, I know that in the Middle East, the Egyptian model, which is a variation on the model law, and actually a very good law. We have no problem with the Egyptian law, except that perhaps it is not as comprehensive an enactment as we think would be desirable, and we have newer generations enactments. Of course, the most vivid illustration of that is the enactment in Bahrain, which was a full enactment of the revised anti-trial model law. In between those two models, there are a number of cases. We are currently reviewing, the newly adopted law in Qatar to see to what extent we in Secretariat parlance would consider it an enactment of the model law, which, by the way, opens an interesting question. What is a model law country and what isn't? That has, I won't take you into theoretical developments or general reflections as to what a model law is. But of course, being with the United Nations and on the other hand, on the one hand being promoting the model law and on the other promoting the adoption of international conventions in a variety of fields, including in this one, the New York Convention, we cannot but be impressed by the different situation that is created for us between the conventions and the work done for us by our colleagues at the treaty section, who keep a very detailed and hard to challenge account of which country, which province, which former colony has or has not adopted a given instrument and what the reservations are. This is a very clean and very detailed and structured approach to enactment of international models. With model laws, we are in a much less rigorous area where the Secretariat, us, we have to make a judgment, which by the nature of things is sometimes a bit subjective, and we try to make it as objective as possible. Judgment as to whether an enactment which purports to be or claims to be an enactment of the model law, or on the other hand does not refer to the model law but might be actually very closely modeled on it, where a given legislation reform should be listed as an enactment of the model law. And of course, it is it's not just a question of statistics or a question of keeping track of successes or of the United Nations. It's also a question of coming back to our main goal of promoting arbitration. It is also an issue of making it known to the world that a given country is truly, in our view, a model law country, and of course the impact of legislation based on the model law to promote arbitration and to promote investment and to increase the attention given to that country by foreign companies and foreign investors is considerable. So this has a very practical impact, and this is something which is conducted within our Secretariat. Recent developments, I should probably go a bit in the area of arbitration rules, transparency rules, and conclude on the Transparency Convention, and please stop me if you think I'm already taking too much of your time. The arbitration rules is an interesting instrument. This is another instrument of soft law based on, it's a model contract, based on a very strong approach to party autonomy, which has been created in 1966 as an all-purpose tool. It is, and I say this with Mr. Moore in the room, it is we sometimes hear, sometimes also from ICC circles, that the anti-trial arbitration rules are for ad hoc arbitration. This is not something with which we would agree, actually. The anti-trial rules are an all-purpose set of arbitration rules which can be used for ad hoc arbitration, which can and have been used as a model by a number of arbitral institutions. It is a set of rules that can apply to commercial and to investment arbitration alike, and to private or interstate arbitration. And of course, we have examples of uses of these rules in all those categories. The important thing we realized, I think, when when we decided to revise the 1976 rules after 30 years of existence, was that there was broader use of those rules in the area of investment arbitration than we would have expected. We keep no statistics, of course, on the use of the anti-trial arbitration rules, but when we reopened the discussion about the text, it became clear that a considerable portion of the uses of the arbitration rules was in the field of investment arbitration. It is calculated by our colleagues in UNCTAD, who do keep statistics as well as possible on these issues, that about 30% of investment arbitration cases are decided on the basis or conducted on the basis of the anti-trial arbitration rules, which makes us totally unwillingly a competitor to ICSID. And I insist on this idea that we are great fans of the Washington Convention. We're absolutely not trying to compete. It just is a fact that knowingly or not, we came to offering an alternative which is based on the arbitration rules and the New York Convention for the conduct of investment disputes. So the question was whether we should now engage in, as opposed to what had been the approach until then, a specialized approach to arbitration rules. Should we create rules should we update the rules specifically with investment arbitration in mind? That option was not adopted by Antitrial. The idea was that we should try to keep this all-purpose, all-terrain nature of the arbitration rules, generic nature of the arbitration rules. But of course, we need to be aware of the specific needs of investment arbitration. If there is something else we can do to assist investment arbitration, we should do it, and that is particularly indispensable at a time when investment arbitration is facing such a crisis and such worldwide criticism. So we went into a number of directions to our starting point. It's important to understand that is not that we would necessarily want to create anything new, but we do have to face in detail, seriously, the difficulties that may have arisen in the functioning of the investment dispute resolution system and the perception that may exist, which may be a little bit of a different problem than the actual legal difficulties as we would see them. The perception problem that needs to be taken seriously, in our view, in this respect. So the first trend was to prepare the transparency rules for investment arbitration. I will not again go into the detail of that. It's a very comprehensive text which actually produced a much broader spectrum of transparency promoting provisions than we would have expected when we started with this project. It really aims at implementing transparency at all levels in the conduct of investment arbitration. The next step, of course, was the Transparency Convention, which intends to make these rules also usable in the context of the pre-existing investment treaties. I think we have noted fairly good popularity of the transparency rules in new treaties concluded after 2014, and I think Oman has one of those in the region. But of course, the big question is not so much what will be done with future investment treaties, but the extent to which the Mauritius Convention will make the transparency rules applicable to existing treaties. And the promotion of the Mauritius Convention in the region, in the Middle East, is something that remains to be done. Last word before I conclude, and I hope I haven't already spoken too long, the next steps. I was very interested in listening to President Moore on the issues of ethics in arbitration. This is also one area which has been brought to UNCITRAL's attention, interestingly enough, by Algeria. This is an Algerian initiative which brought this item on our work agenda, and we are going to start working, as always, in cooperation with all interested, not only all interested governments, but all interested non-governmental entities, to see if there is merit in producing a United Nations message, so to speak, on the ethics of arbitrator without necessarily reinventing the wheel and without necessarily and without, of course, ignoring the many instruments that already exist in that field. But coming to the perception issue I was mentioning, it is important, I think, that the issue is thoroughly reviewed at the United Nations level. We will also, still in that area of future work in the field of investment arbitration, pay attention to, this is fairly technical, but to parallel proceedings and steps that may be taken to limit the excesses in that area. And the main area would be this proposal that is currently championed by the European Union and Canada, and followed by the rest of the world with interest and quite a bit of anxiety, I suppose, in some circles, to create some appeal mechanism, possibly going as far as creating a specific court for investment arbitration. Our message so far has been that these issues are, again, deserve serious consideration, and they deserve serious consideration not only within the closed circle of a transatlantic conversation, important as that conversation may be, but if a satisfactory result is to be reached, this will require a truly intergovernmental process at the universal level, which the United Nations is offering. And I, of course, without prejudging what the decision of our member states will be, I currently have the impression that this approach, relying on an open intergovernmental negotiation, is gaining momentum. So this is something which will be further discussed at our annual session in July, and of course all your countries and all your organizations present and represented in this room are invited to participate. On this point I will pause maybe, and of course I'm available if there are follow-up questions. Thank you.
Thank you very much for this very insightful presentation. On that point, I think we all agree on the importance of a proper legislative framework. We know that France was at the forefront of even having an arbitration law issued even before the 1985 UNCITRAL model law. In the UAE, there is a very much anticipated federal law on arbitration. In the meantime, I think it's very fair to say that France has been a long-standing historical legal jurisdiction who has shaped and influenced many other practices across the world, and that the UAE, on the other side, is a very young, ambitious nation who has been witnessing for the past few years only such a huge economic growth, which has also prompted the development and the overhaul of the legal infrastructure. And it's very fair to say that the authorities have been pretty receptive and keen on developing a proper legislative framework. Needless to say that with the economic growth came as well the development, a huge development in arbitration. So if you go back to the early 90s, we only had, I think, one center for dispute resolution, specifically related to arbitration. And nowadays, we have over 90 centers across the region, which is, I think, a very commendable growth. Also, needless to say that specifically with regards to the UAE, I'm sure most of the audience is familiar with it. The UAE, contrary to France, which is a pure civil jurisdiction, is actually what we can call a hybrid jurisdiction. So we have the onshore jurisdiction, which is governed by civil law, inspired by mainly the Egyptian, Jordanian codes, which in turn were also derived from the French laws. But also there is the choice of offshore free zones, which the main of which is the Dubai International Financial Center, and most recently the creation of a new seat in Abu Dhabi with the Abu Dhabi Global Market. I'm very interested probably to hear from Kareem, from his own perspective, on the interaction between civil and common law, and how has that shaped his practice.
Good morning. Thank you, Sarah. So the interaction between civil and common law in the UAE, or generally speaking in the region, is a very, very interesting subject, because it shaped not only the way of conduct of councils, but it shaped also the proceedings. And I'm talking about the arbitration proceedings before going to the litigation or the court proceedings. As Sarah said, we are in a civil law ocean, except for Saudi Arabia that has an influence of religious laws. But however, if you take all the other countries in the region, from Qatar to Bahrain and Oman and the UAE, this is a civil law ocean, and we have two small islands, which are the IFC and the Abu Dhabi Global Market, which are common law. However, this is for courts. In arbitration, it's the contrary. We have disputes arising out of the Arab world, governed by a civil law. So the governing law of the contracts is maybe Qatari or Bahraini or UAE. However, the practitioners are coming from different backgrounds, and if we see that the practitioners are actually more common lawyers than being civil lawyers. And this has shaped actually into the whole proceedings into a kind of a common law approach to the arbitration proceedings, as opposed to a regular ordinary civil law approach. Now, I know that for a lot of you, this is not something new. However, we can say that today it's very hybrid between the two approaches in the proceedings. But from time to time, we see a common law practitioner that is coming with new ideas that has been adopted maybe in a litigation or court proceedings in his own country, that is trying to, let's say, input this into or transpose it into an arbitration proceedings. And if we have a civil lawyer from the other side, we will have the objection on this. Also, we are today, navigating in a very hybrid system that, for instance, that has adopted the soft law, some of the soft laws that has been discussed today. One of them is the IBA. IBA rules on the taking of evidence in international arbitration, which is in a common, let's say, is very common between civil lawyers and common lawyers in arbitration. Now, when it comes to enforcement of the award, then we would go into more a civil law kind of litigation. And if it is not prepared before, during the arbitration proceedings, we will end up by having some hurdles in enforcing the award. So, bottom line, what I'm trying to say, it's a very hybrid, very challenging times for all lawyers coming from both sides. A civil lawyer speaking Arabic or a common lawyer speaking Arabic is a must in the region. This is what I can conclude today, because you need to understand what's happening after the award and not only during the arbitration proceedings. the after award is the most important part of it, because, you know, arbitration, when you initiate arbitration, is actually to get your right recovered. When you have an award, you have your right that has been recovered, but the enforcement is actually making your award being money in your pocket. And this is the aim of arbitration at the day. It's not a sexy exercise where people would go. It's recovering some money to the client that has actually initiated the arbitration.
All right, thank you, Karim, for this. I know, Mohammed, that you practice in a purely civil jurisdiction, but I'm sure that in your practice you've seen the interaction in some form of the other between civil and common law. So, for example, with proceedings conducted before a common law qualified tribunal, or members of the tribunal with a common law approach trying to interpret probably practices or concepts of civil law, and vice versa. How has your experience been with that so far? Because I think more and more with globalization, we're witnessing the interaction between civil and common law. Do you think that there are, obstacles, or have any of the concepts been sort of lost? Can we say there's some kind of loss in translation?
I think so. I think there is, as you say, with the convergence of many different legal backgrounds into the arbitral, sort of international, transnational, if you will, arbitral system, you have, and you see that very clearly in the Gulf, especially, because in the Middle East more generally, because you have a lot of common law practitioners applying civil law, and vice versa. And I think you need to think of three different scenarios, really, that illustrate the challenges and the benefits of this cross-culture, cross-legal culture in arbitration. The first scenario is a civil law tribunal, so a tribunal constituted, let's say, from French, Swiss, and an Emirati members applying English law. And that is not infrequent at all, because it would be many contracts in the region, even those that do not involve England at all, would be subject by the party's choice to English law. Now, sometimes because of that, the tribunal will be English law specialized, but sometimes they will not, just because of who the parties chose and so on. Now, in that case, you have a civil law, in a sense, tribunal applying English law. And more usually, what you have is the opposite scenario, where you have, let's say, three barristers applying Emirati law or applying Egyptian law. And of course, the mechanisms and the basic instincts of these laws are sometimes quite different. Telling a French law trained or an Emirati law trained or an Egyptian law trained lawyer there is no such a thing as good faith in performing a contract is sometimes an astonishing proposition. Or telling an English law qualified lawyer that yes, okay, the contract says it should be done this way, but the parties has been doing it in a very different way for the past 10 years. And therefore you should take the conduct into account, is an equally appalling proposition. So what you see in practice are two trends. One trend is that a tribunal that, regardless of their background, will apply and be faithful to the applicable law as it is applied by the courts of that law. So a French lawyer applying English law as an English court would apply it, not as he would like it to be. And an English barrister applying Emirati law as an Emirati court would apply it, not as he would like it to be or not as the English High Court would. And I think that is the sane approach to arbitration. The sometimes unhelpful trend that one can identify in such a situation is the arbitrator who feels the need to sort of modify, modernize what it considers a not sufficiently modern substantive law. So becoming a legislator in a way. Oh, well, yes, it says that, but that's a very old trend. I think it should be interpreted in this way. Ultimately, foreign law is something, and all law is foreign to arbitral tribunals since doesn't really have a forum, should be applied in the manner that it is applied by the courts of that country, because that's the only way to ensure legal certainty. Because when the parties chose Emirati law or when the parties chose English law, they did so with in mind how English courts apply English law and how Emirati courts apply Emirati law. They didn't really think, oh, well, this tribunal will actually modernize that law. That's not the job of a tribunal. That's not to say it's not good to have cross-legal culture sort of fusion, but that happens by the courts and by the legislators of the relevant countries. So, for example, estoppel, which is a very English law mechanism, is now widely accepted in many civil law jurisdictions. You have, in France, over the past, let's say, 15 years, slowly but surely, notions of procedural estoppel have made their way through into French procedural law. Similarly, in Egypt, for example, by a 2006 Court of Appeal decision, Egyptian law fully adopted both procedural and, even a step further, substantive estoppel as a means of contract law. So cross-legal culture fusion and conversions is a helpful and necessary feature of globalization, but it should happen in the right way, not through be discovered sort of haphazardly by parties through different arbitral awards.
All right, thank you, Mohammed, for that. I think a good manifestation of the interaction between civil and common law in the UAE is actually reflected through DIAC. I know that DIAC, you know, as most of you know, there are a center, one of the most active center in Dubai, and also in the region. You have recently established also, Mercedes, an office at the DIFC. So can you tell us a little bit, you know, provide us with, you know, the reason behind that, the implications, what were you actually aiming for? And I believe it's very important for our audience today to get a sense about the kind of work that you do and probably a few more statistics.
Sure. Thank you very much for your question and for this unique invitation, Sarah. It is true the Dubai International Arbitration Center has been in Dubai. It's the oldest institution, arbitral institution, and to date, it's the one that has the most cases in the region. It is important to say that well, recently we did set up a branch in the Dubai International Financial Center. With the main purpose of allowing our users to be able to enforce DIAC awards before the DIFC courts. And as some of you are aware of, the DIFC courts are more arbitration friendly than the Dubai courts. As we've heard, it's a common law jurisdiction. The common law island in the civil law ocean, as Michael Wang, the Chief Justice of the DIFC courts, once said. And well, their approach is rather arbitration friendly, and seeing the challenges that enforcing awards before the Dubai courts have had, and how there has been an evolution, of course, but still it has been a slow evolution from going to being able to set aside an award because of a matter of so-called public policy when it comes to misunderstood real estate disputes, and also, for example, the apparent or ostensible authority for signatories of arbitration agreements. So there has been a progress, but it's low, and people would like to, because the economy is developing quite fast, people would like to have the judicial on the same frequency. So the main purpose of setting up the branch in the DFC was that the parties would be able to take a DIAC award, even if it was seated in Dubai, in onshore Dubai, through a memorandum of understanding, and take it to the DFC courts and have it enforced. Now, there's a new development with the judicial tribunal, recently created judicial tribunal, which you will probably talk about in the second panel, so I'm not going to go into details on that.
But I think we can I think it's probably fair to, you know, since we're touching upon the recent trends and developments, to share with our audience Decree 19 of 2016, which established a judicial committee with members from both judiciary of both Dubai courts and DIFC courts, the aim of which is try to solve some of the conflict issues, whether positive or negative conflicts arising out of, you know, issues such as enforcement of awards, which are domestic into the DIFC courts. I think this has been resolved because there was a decision issued saying that onshore awards need to be enforced before the Dubai courts. But one question I think remains for the time being, and you know this is relatively new, and the question remains unanswered, is whether, you know, foreign awards, how do you treat foreign awards? So I'm sure that the second panel will touch pretty much in detail on this, but
Yes.
I think it's good to share this with our audience. So please go ahead.
Absolutely. This is a development, and we would like to have a straightforward answer as to how it's going to be solved in the future. We don't know. So far, the only thing we know is that when it comes to domestic awards, if there are parallel proceedings, one before the Dubai courts for setting aside, and the other for recognition and enforcement for the DIFC courts, well, there's obviously only, according to the Judicial Committee, which was set up in October 2016, last year, very recent, saying that, well, no, it's only the onshore courts who will take a decision because of overlapping jurisdiction. So what will happen with foreign awards, as you said, that remains to be seen. And again, I would like to add that this previous decision of the Judicial Tribunal, the seat was onshore Dubai. That was a seat, although the parties were registered in the DIFC as such, they were DIFC entities. It was onshore Dubai. But of course, and this is a question that within the legal environment in Dubai, you can actually have a DIFC seated arbitration. So the courts who would ultimately be in aide et appui, in support of the arbitration, would be the DIFC courts. So to this extent, we don't know how it will be solved. The only thing that we know is, as an institution, and many of the institutions probably will be a follow-up question, what's happening with the proliferation of arbitral institutions in the region? Is it good, is it bad? Well, you have to stay on top of your game and provide the best service available and adapt to the circumstances to remain active and people agreeing to your clause in their contracts.
So part of, I think, adapting also to the circumstances, we've all witnessed also a rise in the number of institutions in the region as well. So most recently in the UAE, we've witnessed the establishment of EMAC, the Emirates Maritime Arbitration Center. I mean, how do you see this? Is it more, I mean, the proliferation of centers, is it more of a healthy competition, or are we really entering into an inflation of centers leading to too much choice?
Well, in my opinion, it could only be a good thing. Competition generally, a healthy competition brings, improves everything. So yes, there's EMAC, there's the DIFC, LCIA institution, there's a Islamic institution as well. And within the Emirates, the different Emirates, there's other arbitral institutions. So it's not only Dubai, it's 7 Emirates within the UAE. And most of them have also their arbitral institutions. And frankly speaking, it could only be a good thing. It leads to a good thing. I mean, for us also, if you don't adapt and provide the best service, you're out. So that's why DIAC also, it's going to publish very recently its new rules. We've been working really hard for that, and it's state-of-the-art rules. And
So when is that due or expected approximately, around when?
Well, they should be within these days before His Highness Sheikh Mohammed, and because it is actually, the rules are approved by official decree, so they're actually law in Dubai. It's not just the rules of an institution. They have the status of a legislation. So whatever it takes before His Highness to have them approved.
All right, well, that's extremely good news. Do you mind sharing with us some of the statistics
Sure.
of the cases that your center has been dealing with?
Absolutely. Just a couple of slides that I have for that, for you to have a better idea. So in average, you can see every year how many cases we've had, but in average from 2010 until December 2016, it's been 303 cases. Of course, some years more, some years less. Maybe it was your follow-up question, but the type of disputes that we have, of course, it's a developing city, and we have a lot of real estate, yes, construction, corporate and commercial cases too, and oil and gas, it's the less. But one has to understand the type of development the city is having, and that will be a reflection of the type of disputes that we get. Yes, well, this is basically the amount that has been at stake with the cases that have been registered at DIAG. In average, again, 5.2 billion per year. But every year is different, but just a couple of statistics to have a good idea.
All right, well, thank you very much for this. I think Karine touched upon a very important point, is that arbitration cannot exist in vacuum. So it operates very closely with the court system. I mean, the aim of which is actually to obtain a ratification and enforcement on the award for the client to be able to recoup whatever the amount of his claim was. On that front, how common are, probably Karim and Mohammed, if you could share with us, annulment proceedings, culturally speaking, and from a practical point of view? I mean, we've seen the UCAS annulment last year, and I'll be very interested to know, about how parties are likely to challenge any award, and most importantly, what's the legal effect of an award which is set aside?
Yes. In my experience, challenging awards for clients that are based in the region cannot give a very accurate percentage, but at least I think it's around 300%. So everybody is challenged. Over my last 15 years, I've seen only one client that has paid without an enforcement proceedings in the UAE, which was a governmental entity. I think they have provisioned this in their own budgeting. So that's what I was trying to say. The client's behavior in the region is very important, because we need to understand that there is a second phase after arbitration that is very likely to take some time to get the award becoming money in the pocket of the client. And the behavior of the clients is that they see, some of them at least, they still see that the nullification proceedings, which just for information, as you may know, are on procedural matters, and they do not go into the merits of the case, but they still see the clients as being an appeal way of nullifying the award. Now, whether the courts are, at least Dubai courts, are receptive or not to arbitration, and what are the statistics on nullification vis-a-vis enforcement, I can give my own statistics. I have been working for 2 property developers on the arbitrations, and I had like a set of 60 cases for both of them. Out of the 60 cases, we won 30%. The facts are against us. The developers stopped actually constructing. So we tried to get 30% of the cases as a win for the client. We lost 70 others, not because we're not good, because the arbitrators were not good. We were good. But, and some of those arbitrators are sitting in this particular room, friends of mine. Those out of the 70 that went to court, 100% have been enforced. That's my particular statistics. The problem is not, in my opinion, the problem is not about enforcing per se, meaning the reaction of the court. Enforcement is more than 90%. The problem is about two things. One, what kind of conservatory measures you can take during the enforcement stage to secure that the award would turn into money after a certain period of time. And conservatory measures in the UAE are hard to obtain. And the second one is the enforcement stage is a long procedure. We don't take the award and go before the Dubai courts and get an exequatur on it. No, there's what they call the enforcement proceedings, where we need to get the stamp of the court to get this award being enforced by the judge of execution. And it is a long proceeding because it's first instance appeal and cassation, so it takes time. During that particular time, if you didn't secure a conservatory measure, you have like 1 year for the other party actually to do whatever they know to avoid paying or avoiding being seized or their assets being seized, etc. So they can prepare themselves in a manner not to pay. That's, I think, the most important point. And this would not take effect unless there is a new piece of legislation based on the model law, I think, to cater with those issues.
And how are usually awards which are set aside dealt with?
Sorry?
How are awards usually which are annulled or set aside dealt with? Are we in?
Yeah, the problem is that under the current archaic rules of the Civil Procedure Code, I don't know if the people here would know what's happening there. Dubai or the UAE is a hub for arbitration because you need several issues to have a hub. It's a mosaic, it's a puzzle. So you need to have disputes. You need to have good regional centers. You need to have disputes with international centers. And there's something that's very important here that I think that the ICC, they have a lot of disputes in the Gulf. And I think that the UAE lately is ranked like number 10 in the ICC disputes, which give you the amount of disputes that you have in that particular hub. You need practitioners. So you have first-tier international law firms practicing in Dubai. You have regional firms as well that have an international expertise. And then you need also the receptivity of the courts. You have two systems. One is the IFC, the other one is the civil law system, and both of them are very receptive. Also, the Dubai courts might have some problems on formalistic issues, and that would be dealt with, I think, by the second panel, or I have my own opinions on it. But what is actually being there is that the lack of a piece of legislation on arbitration. What is ruling Dubai today in the UAE, generally speaking, are 15 articles in the Civil Procedural Code that are more than archaic. We can live without them, actually, and this is what we're trying as practitioners to do. So as long as we have not introduced a new law that is based on the model law, then we will continue in having problems in some of this. The problem that to answer the question just after this brief introduction, is that under the current law, if you nullify an award, that the nullification would extend to the arbitration clause. So there would be no arbitration agreement as well. So you have one shot. You go to arbitration, you have one shot. You have an award that is annulled, you don't have any arbitration agreement, no clause compromissoire after. So what would happen is that you need to go before the court and initiate the proceedings before the courts.
Thank you, Karim. Mohammed, I think you have some interesting comments to share with us with regards to annulment and annulled awards from a French perspective.
Right. Well, the answer to the question, I think, depends on the view one takes the relationship between the courts of the seat and the legal system of the seat and the arbitration system mechanism as a whole. And I think, therefore, the answer to the question, with your permission, is actually best combined with what you had already asked me to address, which is the French approach to arbitration more generally, because they both fit together quite well. Before that, just a word, I think parties everywhere will always, if they can, resist enforcement. Obviously, there is a high rate of voluntary compliance with awards because of the faith that parties place in the institution, but also because they know that mechanisms for enforcement, especially through the New York Convention, will allow compulsory enforcement anyway. But then you get to that relationship between the arbitration and the legal system of the seat. And France has a very particular approach to that, as you've noted, Sarah. Since the 80s and the decrees of May 1980 and 1981, France had a very favorable modern arbitration law, which was followed by many laws in the region. In France, in Europe, you have the English Arbitration Act, which took some provisions, even the Central Model Law, the Swiss Arbitration Act, and so on. Well, it was a decree, but let's call it the arbitration law, had all the features of a then modern arbitration law. The principle of autonomy of the arbitration clause that allowed the arbitration clause to be autonomous from the contract in which it was placed, the principle of non-interference by state courts into the merits of the dispute, the principle of competence, allowing an arbitral tribunal to judge its own jurisdiction and precluding the state courts from looking into the merits of the dispute which is subject to arbitration. But that did not really distinguish the French arbitration law from, say, any other modern arbitration law or from the model arbitration law of the UNCER trial, which was then followed in many, many jurisdictions. What really set aside French arbitration law and arbitration approach is the concept of delocalization. It's the notion according to which France looked at the arbitral institution as a whole as an independent sort of transnational justice system that sort of floated above domestic legal system. And perhaps the best code describing that is a code by the Première Chambre de la Cour de Cassation in France in the Poutre-Bailly decision, which said that an international award is not connected to any national legal system, and it is a decision of international justice whose validity is to be examined by reference to the applicable rules of the country where recognition and enforcement is sought. So that delocalization system, that idea that arbitration, be it the arbitration agreement or the arbitration award, or the process more generally, is completely disconnected from the law of the seat, allowed France to have an approach that basically allowed it to disregard the views of the seat on any particular question. And I think you can think of that in two very clear ways. One is if an arbitration agreement, so let's take two practical scenarios. Let's take the scenario of a French producer, let's say a French cement producer, selling cement to a UAE buyer, to an Emirati buyer. And they pick up the phone, yes, I'll send you 2 tons of your cement next month. They don't actually write a contract in writing, but they agree to arbitration in Dubai. Now, there is no written arbitration agreement. The applicable law that they agree to is also Emirati law. Normally, you'd say the arbitration agreement is void, there is no agreement, because under Emirati law, that would be the consequence. But let's say an arbitral tribunal does assume jurisdiction, nevertheless, and issues an award. French courts will, in accordance with French law and the French decree, assess that arbitration agreement by reference to French law. They wouldn't look at Emirati law. They would say, there is no form requirement for arbitration agreements. Oral agreements are valid, and therefore, I recognize that arbitration agreement. I will enforce it, and I will therefore recognize the arbitration award that was issued on the basis of that arbitration agreement. And that the same logic applies not just to the agreement, but to the award. And for that reason, if in our same example, the dispute led to an award in Dubai, as per the parties' oral agreement, and the Dubai courts set aside the award because under Emirati law, oral agreements are not valid. That award will itself be recognized in France as per the principle, which I'm sure will be discussed in the second panel, that French courts do not see setting aside of the award as a ground for refusing its recognition. The philosophical basis for that rule is the delocalization, i.e. the fact that even though the arbitration is seated in Dubai, as far as the French court is concerned, that arbitration is not connected to the Emirates or to the Emirati legal system. It is an international award that happened to take place in Dubai, and it's merely a physical location more than anything else. That's really concretely what the view becomes. And so that's the philosophical reason for it. The textual basis for it is that Article 7 of the New York Convention allows France to adopt a more favorable approach to arbitration, and therefore it allows it to apply its own domestic law, which in this case would be the decree of 2011, which replaced the decrees of 1980 and 1981, allowing for the recognition of awards set aside at the seat. So, so again, I mean, as Karim was saying, a legal framework is important, and of course, the new long-awaited Emirati arbitration law is much awaited, and it would help provide practitioners everywhere with clarity as to how arbitrations unfolding in the Emirates will go. But as far as the French court is concerned, they wouldn't really look at that anyway. They will in any event apply the 2011 decree, which sets its own rules and will apply to basically any arbitration taking place anywhere, as long as in keeping with that philosophy that arbitration is not connected to the legal system of the seat.
Karim and Mercedes, probably you want to add something to that?
Yeah, I just want to add to Muhammad something very, very important. The difference between the two judiciary is actually very important here. The UAE judiciary, as Renaud was saying, is coming from I think, magistrate background. The UAE judiciary is to some extent still very. They don't know how to deal with arbitration. Some of them, it's a strange beast, and because it's very striking how they deal with arbitration. You have from one side all the international standards that have been actually embedded in many jurisprudence that you have. So competence, or separability of the arbitration agreement, or you name it, the res judicata, the pacta sunt servanda, all of these are there. But at the same time, and I think the second panel will touch upon this, there's a lot of formalistic matters where it's very striking why they are saying that you should have the capacity or the authority to enter into an arbitration agreement, or the oath taking that Mr. Moore touched upon at the beginning, etc., that can have an effect on the nullification. The only reasonable explanation for this is for me that it's a civil law system and they are civil law judges, and they still view arbitration as being an exception to the ordinary way of litigating, which is a constitutional right. I've seen it in 3 old case laws, but that gives you an indication. They considered going to court as a constitutional right. And when you agree on arbitration, parties are actually waiving their constitutional right to litigate before courts, to go into a private forum. And because of this, they need to ensure that everything is okay. And why? Because they consider this as being an exception. And as long as they consider that this as being an exception, there would be a very limitative interpretation to the exception as a matter of civil law. And as long as they don't recognize arbitration as being an alternative dispute resolution, putting arbitration like the court proceedings on equal footing, we will still have some surprises from the time to time. The 2 real estate cases that Mercedes touched upon in public policy were very strange cases. They have been criticized now, they changed. The Bechtel case is one, and you can see many other reactions on this. The problem is that those reactions are the only ones that are publicized. All the efforts that are made are actually not publicized. Gossip, bad news is gossip, and people would like to have bad news and gossip. You don't see in Paris Match a nice thing. You see always that this actor is actually divorcing from that actress. And then the same thing in the arbitration. When you have a bad ruling, and there are many, it will be publicized and discussed in forums like that. No one would actually look what they have done before. But still, if we don't have a model law and a judiciary that would be considering arbitration as being an alternative dispute resolution, the way the French people are looking at that, we'll still have surprises from time to time.
Thank you. Just to add quickly on this, true that it is a civil law jurisdiction and it is developing as a country. It's only 46 years old. And the idea would be to have a UNCITRAL model law inspired arbitration law in the UAE. We could arrive, as Switzerland has done it, and maybe France, that there's only one specific court that deals with all arbitration-related matters, and they're specialized and know what they're doing. So not all of the courts have to be familiar with this, because it is a strange animal and unknown, and it takes time to get there, as all the advanced civil law jurisdictions have done, to eventually leading to where they are today. If it's been, the new law has been drafts going back and forth for maybe 10 years or more in the UAE. So if this is not happening, I don't know which one is more difficult, but also creating a specialized one hierarchy of courts dealing with these matters, because today it's 3 layers. It's first court, appeal, and cassation to deal with any matter relating to setting aside an award or to ratify and enforce. So after the whole arbitration has finished, you have in the best scenario, 1.5 years more to see what will happen to your award, and even worse scenarios, 5 or 6 years, because obviously there's a lot of guerrilla tactics going on and challenges, baseless challenges, but at the end of the day, they have to be addressed by the courts. So it becomes very burdensome.
I think we're running a little bit late on time. I think it's fair to say that, you know, bad decisions, bad court decisions, and generally take the forefront and are much more publicized, and that we should be very fair in talking about the positive changes, which, you know, are less shared with the public, and the efforts, you know, to try and bring not only Dubai, but the UAE as a general, with international best standards. On that front, I think it's very also commendable to say that the authorities have been also receptive, that they have admitted some errors, and that they are trying to work with the legal community. I think a very much anticipated and hot topic is the amendment of the UAE Penal Code based on the Federal Law 7 of 2016, specifically Article 257, which in its past version only extended to experts and translators, and now with its new version extends to arbitrators and you know, applies more strict and more stringent criminal penalties on the arbitrators, specifically, since we're interested in arbitrators here, who sort of derail from what we call the requirements of integrity and impartiality, as the article puts it. Again, I think there has been a lot of criticism and a lot of exchanges with the authorities who, from our end at least, we are aware that they are trying to sort of put things back into pieces. But I would be very interested to know from all members of this panel to see how, you know, from the UAE, but also from the French perspective, and definitely Mercedes and Renault, how you view this and how has this impacted your practice?
Well, to talk from the institutional perspective, it has certainly complicated things a lot, because Well, first, of course, if there's any decision issued by an arbitrator which might be against the principles of neutrality and impartiality and integrity, can be punished with temporary imprisonment from 3 to 15 years. So obviously this has created a lot of alarm in the arbitration community, and we've had, of course, arbitrators resigning from their current roles, and no matter the stage of the proceedings. And well, this is a novel matter that has been addressed on a case-by-case scenario, and it's only understandable because there have been in Dubai guerrilla tactics even previous to this amendment. What we would all understand as guerrilla tactics, meaning trying by all means to derail the proceedings and to somehow make arbitrators afraid of continuing with their duties. There's some examples against counsel and against arbitrators in civil level and criminal level too. And at the end of the day, after having gone through the 3 instances, first instance, appeal, and cassation, the matters have been resolved favorably for the arbitrators and counsel. But nevertheless, this took a lot of time and effort from the people involved. And to this extent, well, we don't know yet what the threshold will be. This article existed previously, but it not include arbitrators. It only included translators and experts. And to the best of my knowledge, there was only one previous case filed against an expert on this basis, and it was ultimately dismissed. So people might think, well, why are people so afraid of this if there was only one precedent and it was dismissed? Well, we don't know how it's going to be interpreted today, and in any event, because it might probably, unless the threshold is met, let's say that there's a willful misconduct or gross professional misconduct, we don't know what the courts will decide, whether they allow these challenges or they won't allow these challenges. And this goes in hand with the lack of a robust professional body that could, to a certain extent, impose sanctions on counsel or parties, lawyers who put forth these actions. And what do we do? Obviously, there's arbitrators coming from various backgrounds and having qualified in different jurisdictions, but not all of these professional bodies have the same approach to this. We might say, well, there's a lot of English qualified lawyers in Dubai, and there's the Bar Association and the Solicitors Regulation Authority. And also in Paris, there's a strong, Paris Bar probably has the capacity and the interest of imposing the sanctions, but in Dubai, there's none. So it's uncertain. There's uncertainty certainly in the air, and we'll have to see where this leads, and hopefully this will be repealed.
Yep. It's a very interesting article, actually. I will approach it from two angles. From a cynical reality, whoever wants to sue me as an arbitrator, see him in court. I will not decline, and there are many of my colleagues in Dubai who would not decline any nomination on the basis of this particular article. That's the cynical reality. We had to take a call on this. I've discussed this with many of our colleagues, and we're lawyers. We know guerrilla tactics. I'm a Lebanese lawyer, so I know guerrilla very well. And if somebody wants to sue me on the basis of neutrality, see him in court. But to be more seriously in approaching this, it is having a very devastating consequences on arbitration and the arbitration community. I can summarize my points as follows. Many international law firms in Dubai are actually directing their counsels, whether they are partners, counsel, associates, not to take any appointments as an arbitrator. They are asking them if they are currently sitting as arbitrators to try to delocate the place of arbitration, or at least the whole arbitration outside the UAE. For somebody that is working as an arbitration, as an arbitrator in an arbitration, I think that it is killing the efficiency of the proceedings because no one would like to be said that he was not neutral. So if a request for extension of time to submit something, or a new request at the end, or which is normally dismissed because it is at the late, it has been done at the late stage of the proceedings, etc. So we will have to consider those issues that were normally dismissed by the past, to get them more seriously and get them resolved in a more positive manner, which is actually would be delaying the whole proceedings. Because if you look at the provision, there are two issues here: the duty of neutrality and integrity. Integrity is not posing a problem because integrity is corruption, and there is a separate set of rules on corruption. If somebody has been bribed or there's the bribery is dealing with this. The most important point here, it's what is neutrality, how you define neutrality, how people would be reacting, how the judiciary would be reacting, the public prosecution. What is neutrality? I don't know what is neutrality. I don't think that we will have anyone that would be facing any final judgment on the basis of neutrality. On integrity might be because it's bribery, but on neutrality, no. But the issue is today is that the criminal proceedings in the UAE take time. And it might take 4 months, 6 months, or whatever. And if the public prosecutor would request you not to travel during this particular period of time, it's killing your practice, it's killing your clients, it's killing everyone. And you would prevail at the end, but the procedure is long. Are we going to take this challenge? We must continue in taking this challenge because we must continue in believing that that's one of the best resolution mechanisms in the world, and we need to continue in defending this. Are we going to be in a laboratory for a period of time to see what's happening? Yes, indeed. Are we going to be afraid of that? We are afraid already. We'll continue to be afraid, but we'll stand there. Are we lobbying for this? Yes, every day, each time we see somebody that can say somewhere, somehow. You don't have to keep it there. It should be removed. They will tell you we're working on, but it will take time. And in the Arab world, time has no price. It can take forever, like the arbitration piece. The arbitration draft, or many drafts that Hassan Aram and me have seen for the last 10 years, are always there and have never crystallized. So I hope that the lobbying that is done by many local practitioners, many Dubai practitioners, Abu Dhabi practitioners, to the federal government to remove this particular arbitrator issue in 257 would come to effect very soon. There are assurances, verbal, that they will not, I will try not to implement it, but we don't know. Guerrilla tactics exist, and it is a reality. Thank you.
Mohammed and Renaud, would you like to add something to this before we take questions from the floor?
I'd say 3 observations on this. The first is whenever arbitrator liability comes up, one needs to have in mind the jurisdictional activity of an arbitrator. An arbitrator is ultimately a judge, and a judge cannot do carry out his mission if without some sort of qualified immunity from being prosecuted civilly or criminally for things that are exercising the jurisdictional activity. So it has to be, the article at the first instance and before anything else has to be clarified to ensure that this does not encompass things like a wrong decision or a misapplication of the law or a failure to extend deadlines or anything that falls, strictly speaking, within the jurisdictional activity of the arbitrator. And that's a principle that you find in many, many arbitration systems. For example, in France, that's exactly the case. You cannot sue an arbitration for, say, civil liability because they misapplied the law. Even if it is a mistake, even if they did misapply the law, that does not qualify as a basis for engaging in civil liability. So this is the first point. The second point is that a judge may be, an arbitrator is also a service provider. And for that, yes, he should be held accountable, she should be held accountable, and he or she need to face contractual or tort civil liability if they do something outside of the scope of their mission as étrangère à l'exercice d'activité juridictionnelle, so that's outside of their mission as a judge, that qualifies as a civil mistake. For example, in France, this has been found in cases where the arbitrator failed to disclose an event that is impugns on the independence or impartiality, and therefore led to the annulment of the award. And then the final point, so that is not just acceptable, but also necessary, because immunity is necessary to carry out the mission, but then accountability is necessary for that mission to be carried out properly. And then finally, the last point is the idea of criminal liability, however. Singling out the activity of an arbitrator or an expert, a translator, for criminal liability seems unjustified in and of itself. It doesn't seem to. So as Karim has said, if there's corruption, well, there's specific statutes for that. If there is some sort of other criminal offense, there are specific statutes for those as well. But the idea that the duty of neutrality when it comes to arbitrator or integrity, whatever, that will actually end up meaning, singling it out for criminal liability seems not just overboard, just seems not necessarily justified, but any particular concern that is proper and that is compatible with the mission of an arbitrator.
Thank you, Mohammed.
Well, I agree with everything that's been said. Standards of conduct, of course, are necessary, as I said, to take care of the real perception issue, if nothing more serious. But going into criminal liability and more, or particularly doing it this way, is the sort of thing that sends a very, very negative message. So this has the potential to single out the jurisdiction as a particularly unsuitable jurisdiction for arbitration. That's certainly the sort of thing we would discourage. Thank you.
All right, well, thank you very much. We'll take questions now from the floor. Diana, please go ahead. Please, just before you start, I would like to kindly ask everyone, before you ask your question, just to introduce yourself and the company, firm, institution for whom you work for.
Thank you very much. My name is Diana Hamadi. I'm a practitioner of law in the UAE. I'm quite active in arbitration, whether as a counsel or an party-nominated arbitrator so far. This is a comment on what Karim has said, in a way saying that he's won 30% of the cases, lost 70% of the cases as a counsel. From experience, no counsel in the UAE in an arbitration loses. So you win for your client, and when you lose, so okay, you're a winner. So, but when you lose, the party that has won against your client will never be able to get, in most cases, up to 80%, the enforcement of the arbitral award. So mainly, as a counsel, you always win. Whether you do win in an arbitration or you just win because the other party would never be able to enforce it. Now, have we come to a point where we can say that the courts in the UAE have accepted arbitration? Not really. We still have that frame of mind of the judges that arbitration is the exception, and that was quite clear when the panel spoke about it. Now, how much have the UAE, and I would like this to be the question, and maybe I want, I don't know, I would wish that Karim and Hassan Arab answer that question for me. How much are we at the point where we would say that arbitration, this is the end of arbitration in the UAE? with the amendment of the criminal law, with the DIFC courts' failure to intervene in the arbitration to lift that burden that we have had lately, and all that, these serious developments lately that would make us feel that we are at the end of arbitration. Thank you.
I think Hassan Arab would like to answer this question. Jana, let me put it this way. We are in a bad cycle, definitely. Everything that has been done for the last decade for arbitration is being a little bit hit, or heavily hit by what's happening. Let me put it this way. The judicial committee that they've spoke about between the IFC courts and Dubai courts have rendered a ruling saying that if the arbitration is in Dubai, within the jurisdiction of the Dubai courts, enforcement should go before the Dubai courts, and they cannot go before the IFC courts, which were actually more favorable to arbitration. It's not more favorable, more quicker into enforcing a judgment. People would go before the IFC courts even if the arbitration is based under the Dubai court's jurisdiction, because it's still in the ambit of the Dubai courts. So they use the IFC courts as a conduit to enforce more quickly what's happening there. So there is a judicial committee that is between both courts to deal with the competence issues, and they issued that you cannot do this anymore. And the problem is that the ruling is not very satisfactory, either on the result or on the development of the arguments. And it was a very surprising ruling, because you have the same people in the IFC courts that have actually marketed this the IFC courts as being conduit jurisdiction. So that's a very surprising ruling. The 257 is a surprising better. The long-awaited draft is also another issue that is hitting arbitration. Would that be at the end? I don't think so. First of all, people would have to honor their agreements. To honor the agreements, you need to go, if you have a problem, you need to honor the arbitration agreement. So if we take the construction cases, which are in DIAC, like 20% of the cases. I know that the ICC, they have a lot of cases in construction as well in the UAE. We have many, many cases to come. As a practice, no, it's not killing the practice. It's not killing the what's happening there at all. It is hurting them. The system is bleeding. They should remove this 257. They should enact the legislation piece. And the issue of the DIFC/Dubai court should be resolved very soon. I have an indication on this. There has been a discussion just on the foreign award enforcement. Foreign award enforcements in the UAE are acceptable. New York Convention has been tried on several times, and it has been enforced. However, what was surprisingly done is that lately the DIFC courts were faced with a foreign judgment, not foreign award, a court judgment that has been issued in England, and it is impractical. In practice, it's impossible today, as per the set of rules of the Civil Procedural Code, to enforce a foreign judgment in the UAE in the absence of any treaty, whether bilateral or multilateral treaty. And there is no treaty, surprisingly, between the United Kingdom and the UAE. So what's happening is that they are now using the DIFC courts as a conduit jurisdiction to enforce the foreign judgment. The DIFC courts are issuing a judgment, which is a DIFC judgment over the judgment of the foreign judgment. So, and then they go before Dubai courts or any other courts in the UAE to try to execute this particular judgment. So the DIFC courts have actually issued a judgment for this London, this English foreign judgment, and one of the party, the victim, between brackets, have initiated a ruling, initiating a case before this judicial committee that is between the IFC and Dubai courts, and the Judicial Committee dismissed the case. So for foreign awards, I think there are indications that it would still be a conduit jurisdiction. For foreign judgment, definitely it is. I don't think that this is the most important point today. The most important point is that 257, we need to move it, and we need to go quickly to an arbitration model law like peace in the UAE. Arbitration is not dead. I'm still alive, you know, and Hassan Arab too.
Any other questions? Oh, Roland?
Yes, Roland Ziad, Indicators. Do you have any further insight as to what triggered the amendment of the UAE Penal Code?
Hassan Arab would like to answer this question. I've asked the question. I had several gossips. I don't believe in rumors, so I don't have a certainty of what happened. What I know is that it has been a very, very late amendments, because the draft of the law that was actually, this is not only one article, there was an amendment to the penal code in the UAE, and one of those amendments at this 257, and the last draft that has been actually disputed to the judiciary for comments, this particular modification was not there actually. I don't know what happened, and it has been introduced. There are many stories, but you know, in the Arab world there are a lot of stories.
Mm-hmm. Why doesn't Hassan Arab?
Because Hassan Arab is part of the second panel, and we're trying to limit the scope of the jurisdiction of the first panel. So I think, Hassan, you're gonna have plenty of things to share in the second panel. Right now, we're gonna try to wrap up, but to answer Roland's very interesting question, I agree with Karim that there has been a lot of gossip about the foundation or the reasons leading to that article. But I think, needless to say, that I think whether those are true or not, I'm sure that there has been some kind of prompt for the authorities to try and put into picture a good framework for standards. Whether it was done the right way or not, I think this is another issue. Let's take a couple of more questions. Ziva. Ziva?
Thank you. Ziva Filipic, counsel at the ICC. Follow-up questions on both are on the topics that Karim was just discussing. One is the penal law, the criminal law provision. I was wondering if we perhaps can be informed also by the one precedent, if I understand correctly previously, whether taking the seat, the place of arbitration out of Dubai really takes the issue out of the ambit of this provision and out of the jurisdiction of the criminal courts. Normally, the place of the crime would be the criteria, and if the hearing, for example, is here, it's held elsewhere, does that how do we know, and there seems to be a general consensus and a general assumption that the place of arbitration is the relevant criteria to attract the jurisdiction of the Dubai courts. I was wondering what that is based on. And the second question is for Mercedes, really, and maybe I missed the conclusion, but what is then the impact of the decree, of the new decree on the judicial, on the demarcation between the IFC and DIAC? What is the effect of that on the memorandum, on the understanding that you said DIAC has concluded? Does it replace it, or what exactly is the interaction? Thank you.
I'm not a criminal lawyer, but I would say that a criminal judge would approach this particular 257 in a very different way. They would not look into the place of arbitration. They would look if one of the criminalized element of the infraction has taken place on the UAE territory or not, or within their own jurisdiction. So even if the place of arbitration, let's say, is Paris, and for whatever reason, the arbitrator is is actually in the UAE and signed the award there, and there was a problem on neutrality, The signing of the award, I think, would entail the criminal prosecution to be initiated in the UAE if an inventive, criminal lawyer would try to do it. And we don't have any case precedence on this. There is this case precedence on the expert, but it's not the same context. Experts of courts are, they have to take oath before the court because they are an officer to the court. They have a duty to render reports to the court. So, and translators in the same time, they are what they call assermented, translators. So normally this particular provision was for them because at the end they've taken oath and they've not, the neutrality infringing their own oath would entail criminal charges. Arbitrators don't take oath. Till today, we've been very conservative, and you know that, Ziva, that everybody takes oath, witnesses, experts, etc., in a UAE-based hearing. However, we cannot extend this to the arbitrators and ask them to take oath on their own neutrality, etc. So, in short, I think they would approach it very differently, and I'm not saying that we would not have surprise. It's not a matter of place of arbitration. It's a matter of whether there is an element of the criminal infraction took place on the UAE territory or not.
And just adding to this question, I have a different approach to Karim. I do think the seat of arbitration would be the link to the imposition of this provision, because ultimately they are the courts in support of the arbitration, and whether the court will ultimately, in the end, if there's no reference to the seat, if the applicable law to the merits is the UAE law, they might also take an element of this into account to impose a sanction to this. That, again, remains to be seen. But I personally think that it would be the trigger to the imposition of this punishment in a way. Now, your second question, what will happen with this new decision of the Judicial Tribunal vis-a-vis the branch that DIAC opened in the DIFC? Well, it is my opinion that because there is a memorandum of understanding in addition to, let's say, because the cases that we know of only made reference to, well, it was a Dubai-seated arbitration. They were Dubai-seated arbitrations. And therefore, the courts who have jurisdiction to decide whether to set aside or to ratify and enforce are the Dubai courts. You don't go before the DIFC courts as a conduit. No, you go before the Dubai courts. So I would like to think, personally speaking, that having a memorandum of understanding on top of that might make the Judicial Tribunal to think twice and say, well, hold on, there's another element to that. Whether it will prevail or not, unfortunately, it remains to be seen. I want to think positively, ultimately, but we'll update you when this happens.
All right, well, thank you, everyone. And to end this, as Mercedes said, on a positive note, I'd like to thank everyone, and I'll leave it off to Nadia for...
Many thanks to all of you for enlightening us on these complex topics. We'll have now a coffee break, and we will be back in 15 minutes for the second part of the conference. Thank you.
De groupe après.
Ah, ok.
Voilà. Bah, merci beaucoup.
D'autant que je ne sais pas qui a l'idée que ça va se limiter au siège de l'arbitrage. Enfin, là,
On ne sait jamais.
On tombe dans la question de compétence.
Non, mais exactement.
Il y avoir toutes sortes de critères de compétence.
On en a quelques-uns déjà de signés.
Qu'est-ce qui se passe, Popeye? C'est très bien.
Ah, il était pas trop bien, Timo et...
Ah non, mais Timo...
Et Pumba.
Moi,
Pumba et Timo.
moi, je veux une cigarette. J'en ai plus. J'ai perdu mon paquet.
Bah...
Second part of the conference. Thank you. pas moi. Oh, j'ose pas. Okay. It's now my pleasure to introduce you to Arnaud Renoir, who will be moderating this second session. Arnaud Renoir is a distinguished professor at Paris Dauphine. He was, since recently, the vice president of the Paris Dauphine University, in charge of the international affairs, and he authored several publications and books in the fields of international law, international private law, and arbitration. Arnaud, thank you very much to have you here. We are very honored to have you here today. Thank you.
Well, after all, not complicated. This is my welcome. Bienvenue à Paris Dauphine. Thank you for the distinguished part, which means that I've probably crossed the line in terms of age at one point, okay, because old professors always distinguished. I'll try to not catch up the time, but we'll try to move as swiftly as possible. Second part of the morning, and I know that we're edging towards lunchtime, so it's going to be hard to get your attention, but we'll try to do something about this. Second panel is about the enforcement and the recognition of foreign arbitration awards in both jurisdictions. We opened the session this morning with a very strong statement by President Moore about the necessity to end complacency within the arbitration community. And this made me think about something that was sung, I think, in the 1960s, maybe 1963. The times, they are a-changing, and that was Bob Dylan, it was a long time ago. But again, they are a-changing. Before giving the panelists here a chance to come up with their different opinions on the recognition and enforcement aspect, I would just like to make a very, very brief comment. It's about the international context regarding arbitration and regarding, let's say, legal regimes and legal systems. We had a talk this morning about civil law versus common law, although as I said to one of the panelists, my views here would be that we used to say mind the gap between civil law and common law. I think that we're moving away from that. Generations of lawyers that have been trained in both systems, generation of businessmen that are moving in different jurisdictions. We probably need to focus much more on efficient institutions, efficient mechanisms, rather than what is actually coming out of the French law tradition, the Italian law tradition, or the common law tradition. And I think that there's a move forward here that's pretty important. And I do believe that arbitration, and international arbitration, is actually playing a role in that, and in bringing towards a new legal culture. But saying that, we should never forget that international law doesn't really exist, and this is a professor that teaches international law that is saying that. It doesn't really exist because it doesn't really have a forum, and so it has to come down to the ground at one point, and it needs a jurisdiction. It needs a local legal system when you look at enforcement. And so it is crucial, it is fundamental in looking into arbitration, not forgetting that the recognition and the enforcement of the awards needs to be at one point linked or connected with a given jurisdiction. And so I think that it speaks for itself, the importance of this panel, talking about enforcement and foreign awards. For that, we'll have Jalal Al-Adam first, maybe to give us a brief, or not so brief, as he wants, overview of the recognition and enforcement of arbitration awards practices, both in France and in the UAE.
Thank you, Arnaud. I'll indeed try to be first general and second brief, meaning I'll try to limit myself to 10 minutes. I think already a lot was said about enforcement this morning, at least for the little I heard, coming a bit late with apologies. I do confirm that there is a convergence between civil law and common law jurisdiction, but to some extent. It is true because somehow one of my best mates in the arbitration field is my friend Jacob, and he's from a common law background, I'm from a civil law background, and we get along quite well. At the same time, I think it is a genuine mistake to consider that because of the predominance of English practitioners, especially in Dubai, all of a sudden the UAE would have become a common law jurisdiction. It is true you have the DIFC, which is a creature apart from the rest, but yet wherever you go, at least in the MENA region, the influence of the common law rationale is there, but not to the extent that you could say that those countries have become predominantly common law jurisdictions. That having been said, I'd like to mention 2 points also based on what we heard. Especially from Karim and Hassan, or what Hassan would have liked to say if he was given the chance to speak, and echoing the question by Roland, where this provision comes from, this new provision from the Penal Code. And I think it is very telling that you people, and I did speak to also other people from the Ministry of Justice. With Guillaume de Roubaix, we were last year there, that no one actually knows. No one really knows where it has actually come from. And it is exactly happening for the arbitration draft, which has been pending for years and years now. You had already a draft like 5-6 years ago. It was about to be promulgated, and all of a sudden it was withdrew. I think for the best, because it wasn't very good. But again, the same. There is some disconnection between the practice and how laws and sometimes the judiciary functions. And I'm going to give you some very practical examples because I think this is a true problem, and I think it is applicable to many Arab countries, i.e. the problem of the independence of the judiciary and the fact that it is trying sometimes to play a role in the benefit, in the interest of the country, and sometimes not. Now, it is true that the independence of the judiciary is sometimes challenged, even in France, but I will not get into these political aspects. The statutory frame is completely different in the two countries. I think that without getting into the specifics of each provision, what one would need to know as far as enforcement is concerned, and I think it's quite unique because you don't have, other than in France, to the best of my knowledge, that specific proceedings. You want to enforce an award, you go to the TGI, the first instance court, and you get an exequatur order. It's a next party order. And this is quite rare because you don't have it even in common law jurisdictions. And it is really making life easier for a winner to basically get that first step in the enforcement proceedings, because it's just the first step. And it basically changes the whole dynamics compared with many other systems, and especially with the UAE, where you basically have to start from scratch the whole proceedings, first instance, second instance, and third instance, and you have sometimes to re-adjudicate the whole matter. So that's a very important point. And I'm going to ask you, at least for those who did not go through these proceedings in France, how much time you think it takes to get an order of exequatur, even for a foreign award. Thomas? Yeah, it can take no more than 2-3 days, which is really, I would say, breaking the records. It can take often a bit more time, but it's really something. It's definitely something compared with getting a first instance judgment. So that's one. Now, it doesn't mean then with that you can basically enforce. And that's a very important matter on which Vandenberg has always insisted. In recognition is something, enforcement is something else. That means that to get basically to seize assets, you first need to get that order, and then on that basis, you go to the enforcement judge, and then you have to adjudicate your matter. But that's not how it works in Dubai, where the same judge would basically deal with the two matters at the same time. Now, what is important to also bear in mind is the difference in the requirements of the award, the formal requirements. And this is something which all the practitioners based in Dubai know a lot about. In France, it's really the minimum. A signature, even the chairman can basically settle the dispute by himself. I sign by himself the award. And it's true that in some Arab jurisdictions you would have the same, but it's very rare. When you don't have a majority, then the chairman can go ahead and sign by himself alone the award. That's not exactly the case. You have many heavy formal requirements, one of which is that every page of the award must be signed. And that's simply a killer. And it goes to the extent that even when the award is considered to be a foreign award in Dubai, because the seat was outside Dubai, the UAE, you go and recognize that award, and it's not signed for every single page. The judge would deny recognition on that basis. Well, you have a couple of cases like that. Fortunately, they were reversed at the appellate stage. But that's one point to bear in mind. The other thing is that because of how the code of civil procedure is structured in the UAE, you don't have what in France we have, i.e., we consider in France here the foreign awards, the international awards rendered in France as foreign awards. It's almost the same category, subject to a few caveats. But in the UAE, that's not the case. It's either a domestic award or a foreign award. What does that mean? That means that an international award or case rendered in Dubai will be, to some extent, mainly subject to the provisions of the Code of Civil Proceedings. That makes the life of the arbitrators a bit heavy, and I'm sure that many of you who have rendered awards in Dubai know what it takes, basically, to render an award in Dubai. That means, practically speaking, you have to fly to Dubai and you have to get this proof. Speaking of Vandenberg, he even showed me once a picture he took because he basically had to show some evidence that he was in Dubai signing the award at the airport. So he basically pictured himself with his airplane ticket and the award. And then he flew back to Brussels. But that's exactly what it takes, and that's a result of the fact that international awards are creatures that are like domestic awards and even sometimes judgments when rendered in Dubai. Now, the other point I wanted to mention is that one of the reasons why awards are subject to this rather heavy regime is also coming from one major treaty, of course, to which the UAE are bound. Of course, the New York Convention is a predominant instrument in the UAE, but there's another very important instrument very often used in the UAE, and that instrument is the Riyadh Convention. And the Riyadh Convention is a treaty for recognition of awards and judgments. And that leads many practitioners and many judges to basically consider that awards and judgments are a bit the same creatures. So it's an instrument that does not basically work in favor of the autonomy of the arbitration. Now, I will not get into the comparison between the grounds to basically seek enforcement versus the grounds to basically resist enforcement. And you see the rationale is different, because those grounds are basically listed under the French Code of Civil Procedure as a way for someone resisting going against the enforcement to basically try to prove that the award should not be recognized. So the burden of proof is on the losing party, if you will. Whereas the whole balance shifts. The whole balance shifts in the UAE, where when you have to recognize an award, you have to meet some substantive requirements, one of which is public policy, and I'm sure Hassan will tell us a lot about it. I don't want to talk a lot about the other procedural aspects, but I just want to mention one very important point, which is that the rule in France, especially with the 2011 decree, is that usually a pending challenge against the award will not stay the proceedings, the enforcement proceedings. And that's actually applicable to all other sorts of parallel proceedings. Tierce opposition, or, and I had this case where basically the losing party went to basically have a judgment, a related judgment, unrecognized or recognized as going against public policy in France, and basically relying on this parallel proceedings, go to the enforcement judge and say, well, suspend it. And on that basis, it's not possible to stay the proceedings. Now, in terms of fees, also it's important to bear in mind, because money counts, that to get Thomas ordonnance d'exéquatur, it doesn't cost a lot. And again, it's not a lot, but it's that little that sometimes makes a big change. And it just costs perhaps a few €100 versus what you need to get basically a first judgment recognition judgment. It's much more in the UAE. Now, in practice, I don't want to talk about many cases, just a few that I have experienced. One which has been a lot commented, which was rendered 3-4 years ago. Hassan also knows about it. He was involved. I was involved in that case. It was a subsidiary of Vinci. It's good that Alexi has left the room, because it's actually CCI and not ICC. So there is no confusion about it. It's not an award involving the ICC. And it was against the government of Sudan. And you will be surprised to know that in that case, relying on Article 21 of the Code of Civil Procedure, the first instance, the second instance, and the Supreme Court in Dubai. And we go back to the question of the independence of justice, where you have many judges being sometimes Egyptian or Sudanese involved in those matters. Well, in that case, we knew that there was a Sudanese judge. Well, they said what? They said, you know what, forget about the New York Convention. We do not have jurisdiction simply to adjudicate that case. And guess what? You know what's the reason that was given to basically deny jurisdiction and not even examine the merits of the case? Defendant does not have a domicile in the UAE. Well, by definition, the government of Sudan does not have a domicile in the UAE. But you see that artificial arguments relies on some very concrete provisions of the Code of Civil Procedure. And it's somehow clever to say it. But at the same time, it comes from the fact that awards and judgments are somehow considered a little bit the same.
Jalal, could we?
And I'm finished. I had another case I wanted to mention, which was not very much in favor of the system. It was rendered last year. It's the Fluor case. Perhaps Hassan, you'll say more about it. But here too, because the losing party was an Emirati party, it was decided that there was no enforcement of the case. Why? Because the winning party, a UK national, did not bring the evidence that the UK had ratified the New York Convention. And this is also another powerful argument, but that tells you, again, that sometimes you have to face some big hurdles, whereas in other matters, not involving, by the way, an Emirati national or an Arab national, well, you have very, very favorable decisions in favor of international arbitration. And I'm done. Thank you.
Thank you very much, Jalal. Sorry for the hurry. Second, to say a few words is going to be Nicolas Castel from the French Ministère de la Justice. And I think that the fact that the minister is here and is wanting to say something about arbitration says a lot about the way public authorities in France do see arbitration. Nicolas.
Thank you, Arnaud. Just in order, for starting, saying that I'm very well impressed to be here, very delighted to have been invited to participate in this conference. So, of course, as a representative of the French Ministry of Justice, I can't give you any practical information or any information concerning the enforcement of award in Dubai or in the EU, of course. But what I can explain you is the difficulties that the French Ministry is facing in trying to explain or to support the French conception of international arbitration. Because it was said this morning that the French conception of arbitration concerning the idea that an international award is not connected to any state before the time where the enforcement of the award is sought it's not very well understood, even in the European Union, for instance, because I remember that we have a lot and very tough discussion during the recast of the Brussels I regulation. Of course, it is not the topic here to be addressed, but we had a very tough discussion on that issue, and France was alone. Even the UK were supporting us, but in a very gentle manner, I will say. So it was very difficult to make understandable that an award, an international award or a foreign award, has no state of origin. That's the difficulty, because anytime, and it's also difficult to make understandable that an international award given in France or rendered in France is considered as having no state of origin. You know, it's an international, it's a foreign award in the meaning of the New York Convention. And I mean, Monsieur Soriol will be happy to know that the French Ministry of Justice, the task of the French Ministry of Justice is to ensure the promotion as to the promotion of the New York Convention. So in a very specific or particular way, because we promote the New York Convention by saying that this convention allows France to not apply anymore the convention. So because of person to Article 7 of the convention. And when I try to promote the French conception of arbitration, I'd like to raise the difficulties arising from the other conception. I mean, the conception according to which the award is linked to the state of the seat of the arbitration, or to the state where the arbitration proceedings took place. Because in that sense, this means that the issue is not anymore the recognition or enforcement of an award, but the recognition and enforcement of a judgment, of a court decision given on the award in the state of the seat of the arbitration. So no, the issue is clearly a private international issue. It's not anymore the question of whether you have to recognize or enforce an award, or foreign award, but to enforce the decision given on that award in the state of the seat of the arbitration. And this raises a lot of difficulties. It could be understandable if you look only at the issue of the validity of the arbitration agreement. Why not? You can admit that the decision given on the validity of the arbitration agreement may circulate between states. But it's more difficult to understand this conception when the award was set aside in the state of the seat of arbitration on the ground of public policy. On the ground of public policy. What does this mean? Does it mean? Does this mean that we have to accept, in the state where the enforcement of the award is sought, the conception of public policy, of international public policy of the state in which the award has been set aside? That's difficult. Should we accept that on the ground that it is an effet atténué? Should we accept that it is a reflexive effect of public policy from the state of the seat of arbitration? That's a number of issues which are not dealt with by the New York Convention. And of course, because the New York Convention only focuses on the enforcement of the award, not on the circulation, on the movement of decision given on the awards. So that's the conception that the French Minister of Justice is trying to promote in different forums, and it's very difficult. We have this difficult discussion in Brussels for the recast of the Brussels I regulation. I can assure you that we already have this discussion in The Hague as regard the judgment project on recognition and enforcement of foreign judgment, because the interface between arbitration and judgment is always addressed in the discussion. It's very tough to be sure that no harm is made to the French conception of arbitration. And I think that I will finish my presentation here.
Thank you. So the French stand alone, that's not new. And maybe finally, Hassan Harab is going to be able to talk, is going to express himself, as he will lead us through some observation about the Emiratis approach, and might even answer some of the earlier questions.
Thank you, Arnold. First of all, many thanks for the organizers for giving me the opportunity to be in this panel and this event. When we talk about the United Arab Emirates, a brief background, actually, it's a federation of 7 emirates, and Abu Dhabi is the capital. Dubai is the 2nd largest city, and it's a commercial hub for business for different reasons, actually. One of the reasons is the well-established infrastructure, the facilities that they are giving to the investors, the healthy competition among the international practitioners with the local practitioners. So you will find most of the international law firms, they have the base in Dubai in order to serve the whole region. The other reason, actually, the healthy competition among the international arbitration institutions. And we have DIAC, for instance, the IFC-LCIA, ADCAC, EMAC, ICC with their huge disputes there. Finally, actually, the options of having the civil law system as well as the common law system. So the parties, they have the both options to go to the local courts as well as the DIFC and the Abu Dhabi Global Market Court. And these courts actually, when we talk about the DIFC and Abu Dhabi, they have their own arbitration law to be applied. Now we will go to the second part, which is the UAE court position before and after New York Convention. We joined the New York Convention in 2006. Before the signing the New York Convention, actually, we had lots of issues in terms of the recognition and enforcement of foreign arbitral award. And I cannot remember that the UAE courts recognized or enforced any foreign arbitral award. And it was due to the Article 235 of the Civil Code, which has certain difficult conditions. And the court during that time were explaining, because basically they don't have a BIT with the country where the arbitral award sought, and because UAE is not a signatory to New York Convention, they won't be able to enforce the award. After the joining the New York Convention in 2006, lots of positive changes happened. I can assure that most of the decisions by the courts in UAE, whether from the local level or federal level, were positive, and they applied the most international principles. They, for example, mentioned that the New York Convention is a domestic law, and even if the provisions of the New York Convention contradict with the domestic law, they will apply the New York Convention provisions. In terms of the conditions, yes, there are lots of developments. In terms of the procedures, still we are facing the problem of the time consuming. The case will take between 1.5 years to 2 years in order to get the recognition order. There are actually lots of examples. Ermic case is one of the cases issued by the Dubai Court of Cassation, where they recognized a foreign arbitral award. And one of the challenges raised before the court by the respondent that the award is against the public policy, because the tribunal, they applied the interest. And the court totally ignored that challenge. And they said New York Convention is applicable. And as per the New York Convention, we have to recognize this award. Abu Dhabi Court of Cassation did the same actually in one of their cases in 2011, where the respondent challenged that the jurisdiction, the initial jurisdiction, is to the UAE court to decide on the court as per Article 235. So Abu Dhabi Court of Cassation replied to this and said, we cannot apply 235 anymore. New York Convention is the law applicable, and Article 4 and 5 should be considered. And based on that, they recognized the award. Recently, actually in 2016, there was a case issued in London as per the law of the London Maritime Arbitration Association. And it was against a party in UAE. The court applied the New York Convention. One of the challenges raised by the respondent that the person who signed the arbitration clause has a lack of capacity as per the UAE law. Therefore, the arbitration clause is void. And the court actually were very smart when they noticed that as per the Article 5 of the New York Convention, when you will consider the capacity, you have to consider the law of the seat and not the domestic law, and refused that challenge and enforced that award. Despite these positive decisions, there are actually between time to time some negative decisions, as mentioned by Jalal. In CCI, for example, although actually there was an error of applying the New York Convention, but the court, they have a point of view actually. And I don't know whether to blame the New York Convention, the way they drafted the New York Convention, or the judges, because they don't want to be creative, similar to the French judges, to think beyond the New York Convention. So what mentioned by the court on that particular case, that as per Article 3 of the New York Convention, I have to apply the procedural rules of the country where you basically would like to enforce the decision. And when we applied the civil procedure, we find that we don't have international jurisdiction based on that the matter happened outside of the UAE, the parties are foreign, and they don't have any link to UAE. And they refused actually to recognize that award. Whether we agree or disagree, they had the point of view in that case. With regards to the other case actually, where they said the lack of proving that the UK is a signatory to the New York Convention, the problem with the practitioners, as mentioned by my colleague Karim, that they will look to they will forget the positive trend of the courts and will stick to the negative. The latest development with that case, actually the decision which issued and said UK is not a signatory, was issued by the Court of Appeal. But that decision being rectified by the Court of Cassation, and they basically recognized the award, and they mentioned clearly that it's not, the burden of proof is not on the party to prove that the UK is a signatory. It's a duty of the judge to prove that. So overall, I can see actually that after the New York Convention, we are very positive, although we have problems actually, I cannot deny. But it's not logic to compare a country with the age of 45 years with France, for example, because I'm sure that they had the same problems until they reached to this level. But despite actually, and this is the answer to Diana, although she promised that she will not ask difficult questions, despite the Article 257, despite lack of law actually, despite the problems we have, whether we like it or not, UAE is the hub of international arbitration. Honestly, and ICC, they can confirm this from these statistics they have. So my recommendation actually, we hope, and most of the practitioners, they hope, that it's not enough just to have a law, because we have some other alternative solution, even if we don't have the law. New York Convention is there, we have the DIFC court, we have the Abu Dhabi Global Market. They can basically play that role, especially with the recognition of the International and Foreign Arbitral Award. I believe lack of law is one of the issue, and as mentioned by Mercedes, and I totally agree with her, lack of a competent court with the specialized judges is another issue. So both of them are important. And I hope when the UAE government will consider having the law, to have two different provisions, one to deal with the domestic and one with international, to basically avoid intermixing the provisions.
Thank you. You mentioned the public policy again, and we know this is a very important subject, and I will leave a common law lawyer in Paris, Jacob Guertin, to actually address this public policy issue. Thank you, Jacob.
Thank you very much, Alan. It is slightly odd that an English lawyer should be talking about French law, but here goes. I have been living here for 15 years, and so I know a little bit about this. And what I'm going to focus on now is just one question. How far are the French courts prepared to, what I would describe as second guess, an arbitral tribunal's decision where public policy is invoked either to annul or to object to enforcement? And I deal with the two interchangeably because, as very eloquently explained by Nicolas Castel, because of the French conception, the two are dealt with really in the same way within the French system. So that makes my task a little bit easier, and I can deal with all cases, whether it's about annulment or objection to enforcement together. Now, public policy, as everybody knows, is a very vague concept. It's been used it's been stretched out to cover situations that frankly have nothing to do with public policy in many jurisdictions around the world, and we've all heard about those kind of abuses. But generally speaking, at least in most countries which respect the concept of arbitration, public policy has been limited really to the three areas that I've listed on this slide. First of all, in terms of procedure, questions of fraud, corruption within the arbitral system, et cetera, and obviously one case that comes to mind in France, albeit in the domestic internal arbitration context, of course, is the Tapie case. Then turning to substantive issues, one has really two principal areas. First of all, breaches of competition law, which are clearly, or at least breaches of EU competition law, are now clearly capable of a public policy challenge following the decision of the European Court of Justice in EcoSwiss in 1999. And then what I've described as corruption, etc. And the etc. is important because some of the cases, or at least one of the cases that I'll be talking about in a moment, is not strictly speaking about corruption, but about money laundering. But I put them all into the same sort of basket of what I describe as clearly illicit activities. Now, the starting point in what I'm going to describe is the very well-known case, the very well-known decision of the Paris Court of Appeal in Thales, about which much has been written, including by Alexis Moore. There was in that case a fairly obviously anti-competitive agreement which involved market sharing between two manufacturers of weapons. However, neither party raised this point during the arbitration itself. It was only raised for the first time in the annulment proceedings. The Paris Court of Appeal rejected the challenge made based on the allegedly anti-competitive agreement and came out with some quotes that have been quoted in many cases since. They said that the violation of international public policy within the meaning of Article 1525 of the French Code of Civil Procedure must be flagrant, effective, and concrete. And to make it even clearer what flagrant meant, there was a reference in the judgment to the need that something should crève les yeux, it should poke the eyes out. And they went on to say the annulment judge cannot examine in the absence of fraud or manifest violation the application of EU competition law rules by the arbitral tribunal. And so based on that and based on the fact that they didn't consider there was anything flagrant about the breach of competition law rules in that case, they rejected the annulment application. And so what one can take away from the Thales, or what one used to be able to take away from the Thales decision, because as I'll explain, there's been some developments since then, was that the French courts adopted a, from the point of view of most arbitration practitioners, thankfully minimalist approach. They carried out an only extrinsic review of arbitral awards, and that they really wouldn't second-guess the actual decision of the arbitral tribunal, which of course is totally in line with France's very strong pro-arbitration policy that Nicolas Castel has been speaking about. Criticized nonetheless by a number of scholars, mainly those more from the competition law camp than from the arbitration camp, as you'd imagine, pointed out that in reality the decision in Thales resulted in a kind of mockery of the EcoSwiss decision, because if the Paris Court of Appeal was going to say, of course we're going to review, but we're only going to review in the cases where there's a flagrant breach, then that really doesn't do much for the principle of effectiveness of EU law. But on the other hand, very eloquently supported the decision of the Paris Court of Appeal, very eloquently supported by Alexis Moore himself in a well-known article on that case. Subsequently, the Thales case, the Thales ruling and its principle was followed and confirmed by the Cour de Cassation in the CITEC, the SNF and CITEC decision in 2008. which I won't go into, except to say that that was a case where actually the anti-competitive element was, or at least the breach of competition law rules by the tribunal was much less flagrant, given that the arbitral tribunal in that case had in fact found a breach of what was at the time, I think, Article 81, and had in fact treated the relevant contract as being annulled, and so it was really just a question of what consequences and damages flowed from that finding. So a more complex issue than had been at stake in Thales, and so even easier for the Cour d'appel, confirmed by the Cour de cassation, to say, no, we're not going to go into this. By the way, having said that I wasn't going to go into that case, it's interesting to note that the Brussels court, the Belgian court, did in fact, on exactly the same case, decide that there had been a breach of competition law and refused the enforcement of the decision, but that was then overturned by a higher court in Belgium, which reached the same result as the French courts. Now, those were two cases dealing with competition law, and as I mentioned, there's the other bucket, if you like, of public policy cases, which are corruption cases. And there's a well-known decision of the Paris Court of Appeal in Schneider, dating from 2009, in which concerned a case, an arbitration, where the sole arbitrator had given effect to a contract that was alleged to have aimed at bribing certain Nigerian state employees. And the Court of Appeal stuck with its Thales formulation, its Thales reasoning, and found, with respect to the violation of international public policy, only the recognition and enforcement of the award is examined by the annulment judge regarding its compatibility with public policy, subject to a review limited to the flagrant, effective, and concrete character of the alleged violation. So the court therefore refused to annul the award and applied the same principle that it had applied in Thales, which led to some fairly strong criticism, given that there were some fairly strong indications of corruption in that case. Now, the decision of the Cour de cassation confirming the Cour d'appel's decision in Schneider had been issued in 2014. And in that same year, there were some 3 further decisions, not by the Cour de cassation, but by the Cour d'appel, that suggested, in fact, a significant shift of approach compared with what had been seen in all those cases that we'd seen before in Thales, SNF, and CITEC, and Schneider. In these cases, which are Gulf Leaders, Comis Impex, and Man Diesel, the Paris Cour d'appel each time cited something which was fairly similar to what it had said in the previous cases. However, those with an astute eye noticed immediately that they dropped the keyword flagrant, suggesting that there no longer had to be something that poked out the eyes in order for the Court of Appeal to intervene. But in each of those 3 cases, it didn't intervene. It decided that, in fact, there was insufficient evidence of corruption in all of those cases. Now, I drop figuratively a footnote here to talk about the compatibility of the traditional approach, the Thales approach, with EU law, obviously purely in the context of competition law or alleged breaches of competition law. What we'll see is that the 3 judgments that I've just referred to, the 3 judgments of the Cour d'appel, actually fit very well with a comment that was made in Genentech by the Advocate General of the European Court of Justice, Advocate General Vettelet, where, although he wasn't specifically asked to rule on this issue, he nonetheless opined as follows. He said, limitations on the scope of the review of international arbitral awards, such as those under French law, namely the flagrant nature of the infringement of international public policy and the impossibility of reviewing an international arbitral award on the ground of such an infringement where the question of public policy was raised and debated before the arbitral tribunal, are contrary to the principle of effectiveness of EU law. In other words, he considered, he opined in this opinion, that the approach in Thales, which had been upheld, as I said, in SNF and in Schneider, was in fact contrary to EU law. But as I said, this was okay because in fact there had been the 3 judgments in those 3 corruption cases, which seemed to be dropping in any case the flagrant part of the formulation. And by the way, the Court of Justice, unlike the Advocate General, decided not to get stuck into this issue. They remained silent, as happens quite often in cases before the CJU. They decided not to deal with that specific issue and limited themselves purely to the question of whether there had, in fact, been a breach of competition law in the license agreement in question. So now we come back, and I'm almost at the end, we come back to the issue of the question of corruption and to a very recent decision of the Paris Court of Appeal, which many of you would have seen in Gare and elsewhere, which is the decision in the République du Kyrgyzstan case. The very distinguished tribunal in that case had awarded the claimant compensation for expropriation of his bank by the Republic of Kyrgyzstan. The Republic then introduced annulment proceedings before the Paris Court of Appeal, alleging that the bank in question had carried out activities involving money laundering activities, and that therefore the recognition of the award would violate French international public policy and it should be annulled. This argument, very importantly, had been raised before the arbitral tribunal, and when I say this argument, I mean the money laundering allegations had been raised and discussed extensively before the tribunal, and the tribunal in that case had said, yes, it smells pretty bad. We can see that this guy is in cahoots with the son of the former president. It is rather surprising that the bank has done so well in a relatively small place, not previously known for its banking activities as Bishkek city. But nonetheless, we don't have any positive proof in front of us that there has been money laundering. Well, the court took a different, the Court of Appeal, Paris Court of Appeal, took a different approach. It decided that its mission, first of all, decided that its mission was to establish whether the recognition or execution of the arbitral award would allow a party to benefit from money laundering and thus hinder the objective of preventing such activities. Nothing particularly new in that. But what they actually did was very new. They analyzed thoroughly the financial operations at stake, and they concluded that reliable and consistent and precise evidence indicated that Mr. Bellocan, who was the claimant, had committed money laundering. And they, the evidence, although I'm oversimplifying to some extent, the evidence was basically that the bank had, within a very short period, succeeded in getting a turnover that was considerably larger than the GDP of the Republic of Kyrgyzstan itself, and it drew the not unreasonable conclusion that it couldn't have done that other than by engaging in money laundering activities. So a very different approach from the approach that the tribunal had taken, and as a result of that view, decided that there was a manifest, effective, and concrete breach of international public policy, and that therefore the arbitral award should be annulled. I think we're almost up to 1 o'clock, and so I'll take this relatively quickly. And I'm getting encouragement to take it quickly, so I really will. What we get here is as I've said in this slide, for the first time, a departure, not only a departure from the requirement of a flagrant violation, but also an actual annulment of an arbitral award. So those 3 cases from 2014 that we saw a moment ago actually being put into practice by the Paris Court of Appeal and engaging for the first time in the context of public policy annulment requests in a really in-depth review of the public policy violations. As I said here, the question remains, will the Paris Court of Appeal, and indeed other French courts, apply this approach also to competition law breaches or alleged competition law breaches? That remains to be said, and since we are running out of time, I will leave you to draw your own conclusions, but here are some on the screen.
Thank you very much, Jacob, and horribly sorry for pushing you along like this. Unfortunately, the time constraint being what they are, we have to move on. I was just thinking that you gave us the theme of a future roundtable here on public policies, probably across France, Europe, and the GCC, or at least the Emirates. I have been asked by the organizers to, and don't hit me, I'm just a messenger, to skip the question and answer phase right now, but you will have time just after, of course, to address the panelists. And I want to thank very warmly all the panelists for speaking and trying to stay within a reasonable schedule that we skipped, but that was not your fault at all. Thank you very much, and so I hand the floor to President Moore.
Thank you. What is of interest, though, does it work? Is it working? Yes. What is of interest, though, in this decision is the introduction of the word manifest. And one might query what's the difference between manifest and flagrant, but we'll see what the future holds. Well, I will very quickly close this indeed successful half day of discussions. I hope there will be more of these conferences. I think this will be very useful. One of the features of discussion which I found fascinating is how in Dubai, as Professor Renoir said, the civil law, common law gap seems to have entirely disappeared, with civil law tribunals applying common law tribunals applying civil law, and that is really what arbitration is about, and that is probably one of the great strengths of Dubai. Dubai is a venue for arbitration, for international arbitration, which I still believe to be extremely promising, and I hope it can recover from its current problems. Dubai is fantastically located, close to India, close to Asia, close to Africa, close to Europe. I think from a geographical point of view, it's probably one of the best placed arbitration hubs. It has great infrastructures. It has a strong arbitral institution, DIAC, which I had in several occasions the pleasure to work with, and indeed DIAC provides very good arbitration services. Dubai is, of course, a hub for very large arbitrations. The ICC, for the ICC, it is in the top 10, not only in terms of number of cases, roughly 60, but also in terms of the place of the arbitration. So it is really a pity that we see a number of weaknesses affecting Dubai as a place of arbitration. And I think that in order for Dubai to really move forward and become what it deserves to be, and that is one of the major arbitration hubs in the region, and I really believe that Dubai can be raised at the level of what Singapore is today. I think there are probably three important things to fix. The first is the infamous Article 257. 257 is really a killer for any arbitration place. If this is not fixed, Dubai will suffer in terms that will be difficult to recover from in the future. It is one thing for an arbitrator to be faced with civil liability because you have insurance, and you can hope that in the end But another thing is to face a criminal suit in the conditions that we know, with guerrilla tactics, attacks from disgruntled parties on you, and this is really something that is not compatible with being a relevant arbitration place. The second thing is there are probably issues with the case law of lower courts. We all remember this very odd decision by the Court of Appeal, I think, in Dubai, saying that denying recognition, enforcement of an award, because I think the court said that the UK was not party to the New York Convention. Rather odd. That was fixed in the Court of Cassations, as many other strange decisions from lower courts have been in the past. But this kind of thing creates uncertainty and is again not compatible with what is expected from a major arbitral venue. And you have in not only in Dubai, I have to say, but in other parts of the region as well, this very, I would say, habit of suing arbitrators. I have been the victim of that in Dubai myself. I had to litigate in one case that is, I think, now quite famous. In the first instance, the Court of Appeal, the Court of Cassation. At the end of the day, the arbitrators won in all degrees of jurisdiction, but it is extremely uncomfortable for an arbitrator to be dragged in procedure. I have the same experience now in Qatar, in Doha, so this is not a specialty of Dubai, but again, this is something that I think goes more to the ethics of counsel than really the case law, because there is this kind of national sport of trying to target and shoot the arbitrators, but I think at the end of the day, this is not something that serves the interest of the party to represent. It certainly doesn't serve the interest of the place of arbitration as a whole, and this is something that should be probably addressed in terms of education, training, and raising the legal culture in Dubai, like in other places of the region. This is something the ICC tries to contribute to. We have our regional conference next week in Dubai. I hope to see many of you there. But for now, I really commend the organizers of this conference for a very, very successful day, and thank all of you for your attention.
Thank you, Mr. Moore, for being with us today. And actually, we had to make some modification of the schedule just to fit the time agenda of Mr. Moore. And we will have now the Q&A session. Thank you, Mr. Moore. Oh, no, it's okay.
Okay, so we're back on track. Who wants to shoot with the first question? That was quick, right there. You've been waiting for what, for half an hour?
It's probably for Hassan or anybody else who wants to reply. The requirement to sign the award in Dubai when the place of arbitration is Dubai is religiously complied with. Everybody is flying to Dubai, and as we heard from Gilles, collecting proof that they have flown to Dubai and stayed in a hotel there or similar. Now, I was just wondering conceptually, according to your opinion, what happens, what are the risks of when a tribunal in arbitration with the seat in Dubai does not fly to Dubai and sign the award there? And is this a requirement that the parties can explicitly waive from? Is that effective, or is that just useless? Thank you.
Actually, this is due to the mandatory rule mentioned in Article 212 Part 4 of the civil procedure, which mentioned that the award should be issued in the United Arab Emirates, or else the provisions of the foreign judgments will apply. So having the seat in UAE means that the provisions of the civil procedure will apply, because one of the issues, as mentioned by Jill, is the lack of having the definition of the international arbitration. Although most of the arbitration happening in UAE has international elements, but it's been treated by the court as a domestic because of this article. So what will happen in this situation, we will have two scenarios. Either the court will expect this as a foreign arbitral award, although the seat mentioned is UAE, but because it's being signed outside, they will expect it as a foreign. Or the alternative is that they will apply Article 216 of the civil procedure to annul the award because there is an error to one of the procedures, which is signing the award in the UAE. So
Sorry.
we are between two scenarios, actually.
And is there any case law on annulling for this reason?
But I didn't come across any case actually annulling because it's been because the seat is UAE and it's been signed outside. Karim, do you remember any case?
No, I confirm there are no cases, but I confirm what you're saying, and this has been discussed at large at the time. Hassan, you recall, was the DIAC on this, and we had both of us the same opinion. There are no case law, but there is a huge risk of nullification of an award on this basis.
I am speaking under the control of both Hassan and Karim, who both know the case law being rendered on a day-to-day basis on the ground. They're much better than I do, although we follow with our journal quite closely the case law. My knowledge is that there is nothing about that, while I think the law is quite clear about that point. And I think the risk is rather significant if someone had to basically take that risk. And I would say, but on two different related aspects, which is the signature of the award, of every page of the award, and the fact that you would need to have terms of reference. On those 2 points, because the law is not very clear, well, on those 2 points you have case law in favor and against the validity of the law. If you do not sign the award for every single page, by sign I do not say initialize, but sign, or if you do not refer to terms of reference, although the applicable rules of arbitration, like those of DIAC, would not impose such terms of reference, then again, you would run a risk. And in those 2 cases, you have cases in favor of the annulment of the award and cases basically validating the award.
Just the second part of the question. Sometimes we see parties agreeing to that the tribunal can sign outside of the UAE. Does anybody have any experience with that or any opinion?
The seat is UAE and they've been advised to sign. It has a risk, as I said, actually. We will be between 2 scenarios. I would like just to comment on Jill's comment with regards to the signing each page. Actually, part of the problems on the practice of the arbitration in the UAE is we as a practitioners. Because if we go through the case laws, it mentioned that at least part of the reason should be part of the last page, which has the conclusion. So if the reasons is there, or part of the reasons is there, it's enough to sign the last page. But if the conclusion itself is in 1 page, then you will require to sign the whole award, actually. So part of the problem are we, and we are trying to make sure that we will not handle that risk. So the best way is basically to sign the whole award.
And I think we had one question down there, then another one over there.
Yeah. Hi, Ravinder Thakral at Brown Rudnick. I've got a question about the Judicial Tribunal and the role of the Union Supreme Court. Some people have said that the Judicial Tribunal was introduced to prevent the Union Supreme Court from resolving jurisdictional conflict between the decisions of two emirates. If that's right, why is it that the Union Supreme Court is not used in this way to resolve those conflicts of jurisdiction, and instead they're resolved by a newly created tribunal?
Actually, as far as I know, actually, the role of the Supreme Court is by the Constitution, and there is a law actually to give them that jurisdiction. And I know that there was some disputes actually raised before the Supreme Court with regards to the issue of the conflict between the DIFC and Dubai court. The judicial committee which been created, they almost have the same role actually, but maybe they found that because both courts are, I mean, they are actually based in Dubai, so the best way is to solve the issue among the local level is to have that committee. But there is no any conflict between the committee and the Supreme Court, so the parties, I believe, have the option to approach both. Creating the committee doesn't mean that you cannot approach the Supreme Court.
Yes. Thank you. I think there was also a question that was not answered yet, whether or not there is a possibility of a waiver from the parties concerning the requirement of signing in Dubai. I think it hasn't been answered. Now, then a second question from me was, it's not really a question, it's just a very brief comment concerning Mr. Castell's point concerning the concern your government expressed. I would say it's mostly an issue of French law. Why the French international arbitration law does not really care whether or not there has been an annulment in the country of origin of the seat of the word, so where the seat is, it's really a choice of the French lawmaker, of the French Cour de Cassation. So it's much more, if you wish to explain that elsewhere, abroad, it's much more explaining just French law, because the New York Convention is not a limitation to that. You have only Article 5.1e, and you said it very well yourself. Through Article 7, you disapply Article 5.1e, that's all. So I think it's much more just introducing French law to foreign operators, and then more than anything else. Thank you.
I think that's the difficult point. Please.
I totally agree with you, but sometimes it's very difficult in international forum to promote French law. It's better to focus on an international agreement. When I say that we apply the New York Convention, looks French law complies with the New York Convention, then it's more understood than with an imperialist view concerning the application of the French law or the promotion of the French law. So it's just a negotiation techniques, if you allow me to say that.
There's political correctness everywhere. Karim Nassif, did you want to answer, I think? Did you want to say something?
Just wanted to answer Ziva, if Hassan allows me, or he can do on this particular issue. There is no case law on this, but in each and every ruling that you have in the UAE from the Court of Cassations, because the UAE has 3, I think, or 4 Court of Cassations, because there are different judiciary in different emirates, and there's the federal one. So you have in each of those rulings in respect of arbitration, there is a reminder that the court would apply the pacta sunt servanda, and that the agreement of the parties is the law, and that agreement of the parties shall prevail over everything there. So if the parties would agree that a domestic arbitration award would be signed outside of the UAE, I don't think how somebody can after challenge its own agreement, especially in the context of the Court of Cassation saying that there's an agreement between you both to do this.
Yeah, especially when you have provisions of the rule saying that the award is deemed to have been rendered at the place of arbitration, which is basically just confirming that.
The law, if I have it, I don't know, but the law does not say that it should be at the, I think it says that you should mention when you have the location of signature. 214. It says the place where the award has been issued. It doesn't say the place of arbitration. So if the parties agreed, in my opinion, that the place of the award to be issued is in Paris, however, it's a domestic Dubai or Abu Dhabi-based arbitration, I see no harm in that. The only problem is that when it comes to enforcement after, would the court consider this as being a foreign award, or would the court, stick to the matter as being a domestic award? And I think it's better to have it a foreign award because the track record on your convention is largely better than the track record on the domestic one.
If I may add one thing on here, I think the only problem with waivers under these provisions is that some of them, so 210, for example, refers to the agreement of the parties. The fact that 2124 doesn't suggests to me that a contrario, you would not be able to say that a waiver is possible, even if conceptually it should be. Technically, just linguistically reading these provisions, it may very well be that it won't.
I have actually one example. Bechtel case, for instance. Yeah. There was a waiver by the party, actually, that the tribunal can hear the witnesses without the oath. And when he did, his award was subject to the annulment. Because it was against the mandatory rules of the law. So we don't know whether this article, they will expect it as a mandatory rules or not.
I think that we should have a workshop on signing awards and not signing awards in the GCC.
Definitely, because just for the small example, I was issuing an award with the tribunal last week. And since we have to sign each and every paper, the award was 92 pages. So we worked on the font and we enlarged the page to have it down from 92 to 72, because there's one for DIAC, one for each of the parties, and one for us, and etc. So we ended up like having a 3 or 4 hour session of signing,
Well, on these tips and tricks, another one.
Just a very brief comment, because obviously DIAC name has come up in several times, and yes, true. The approach has always been, and as Hassan and Karim have said it, to err on the side of caution. It might not be the most ideal, the most productive, the most efficient, of course, but since there is uncertainty, just better be on the safe side, unfortunately.
Just on behalf of the ICC, I think the approach is exactly the same, but it's just clarifying some conceptually, as I said, conceptually, because practically speaking, I think nobody will take the risk.
Exactly.
If I want to say this, because I remember Alexis Moore mentioning this also in another conference about the support of DIAC in many instances. And it's true that DIAC, sometimes they often say DIAC is not like other centers like the ICC. They don't have like counsel, they don't review awards, but they do provide a lot of help in terms of saying, well, be cautious because there's this case law and you need to be, and this is very helpful because when you don't know actually what are the risks, you're being yourself at risk.
Well, definitely a cost-benefit analysis without knowing the risk and without having assessed the risk, it becomes very, very complicated. I suggest that, and I think I'll leave the floor to Nadia, but we can end the Q&A, but you can take up the subject, the 7th floor, around over lunchtime, and you can still talk about signatures, waivers, and others in a much more relaxed atmosphere. Once again, thank you very much, but there is one more word by Nadia Molinier. Thank you very much for your attention all morning, and thank you again very warmly to the panelists.
Thank you, Arnaud. So with that Q&A session, we conclude this first edition of the France-UAE International Arbitration Conference. I would like to express our deep gratitude to the panelists for their remarkable contributions. Thank you for being here today with us. And At this stage, I would like to address our special thanks to our sponsors and partners, and particularly to Paris Dauphine for hosting and supporting this conference. And lastly, I would like to thank the excellent coordination between the teams in Paris and Dubai. And we look forward to welcoming you very, very soon for the second edition of this conference, which will take place in Dubai. And now I have the great pleasure to invite you to attend a lunch, which will take place at the Espace 7, 7th floor. Thank you very much for your attention.